Recording in progress. Hello.
Oh, dear.
Hello.
Hi, Chair, we can hear you now.
Yeah, sorry about this, comrades, colleagues. Look, firstly, the right now I've been available for 2 minutes. The thing started this problem. I think some people have, and it's happening to me again. You can't unmute or you can't on your iPad, but it suddenly worked. I'm relieved about that. Okay, I think in Kulaleko's explained, I had to go and speak. It's a quite a remarkable thing. I think I should tell you this. It's the first time in my life, actually, as an MP, that you're only passing a bill this afternoon, that already you're required to give a briefing and people are looking into its implementation. Never happened before. So I think we all know that the prime movers for the two-part system has been the South African Congress of Textile Workers, right? They put the issue on the agenda in 2020 with the then Minister Tito. So they called a workshop where they asked Matthew from COSATU and myself to speak. I explained to them the difficulties. It's a workshop till 2 o'clock, but I could be there till 5 to 10. Now, the striking thing is I've spoken to COSATU affiliates many, many times. I must say I was so impressed. It's shop stewards from throughout the country. They're meeting in Cape Town physically, but others who can't are linked. But they started promptly, on time. I've never heard of that, of a union doing that. And it's very interesting, the issues that are coming up. Just to let you know, unfortunately, I could only hear 3 shop stewards, but I've asked them for the recording. But the anger that they have to wait till the 1st of September, I think it's important to know, you see, we're seeing here the practical consequences of the words in a bill and the discussions you've had, we have all had, for at least the first 3 or so people, well, the first person, but I know what the other two, I got a WhatsApp saying what the others are saying in a few minutes now. They just can't wait till the 1st of September, interestingly. These are textile workers. Anyway, that's that. Let's get started. Any apologies?
Yes, Chairperson, I've got an apology from Mr. Okamp.
Oh, yes, he did say yes.
And Mr. Detroit. They won't attend, yes, Chair.
Oh, Mr. Detroit, I'm surprised. Well, I don't know why, but anyway, maybe she's got a caucus. So, colleagues, thanks for coming. Once again, my apologies, but really, it has very little to do with me. The change again, for the Mr. Detroit is probably the GLAB hearings. Okay, so basically, can somebody just remind me what page we're at? Where did we leave off? Maybe MP, you're in the best position to say with your report on the exchanges with the stakeholders from the 8th to the 10th of April. MP, can you remember what page we stopped?
On page 5.
That's what I thought, it's page 5, yeah.
I think bottom of page 4, because I don't think we discussed, the whistleblowers issue from JSR.
Oh, yeah. Okay. So the next issue, so we got here, maybe our number is different. But we didn't do, oh dear, okay. Here we are, page 5. Colleagues, we got the same document as before. And you say we ended at the bottom of page 4. No, it's about, yes, it's about incentivized whistleblowing. Is that where we are?
Yes, Chair.
Okay. So, colleagues, look at paragraph 5 at the bottom of page 4, right? Now, the point here being made is that an MP must help me if I haven't covered the key point, right? If you look at the last section of that third, it says the Protected Disclosures Act only applies to employees. But in procurement, incentivized whistleblowing is often by persons who are not employees, which is correct. The Protected Disclosures Act would therefore have to be radically reconceptualized to enable incentivized whistleblowing in procurement. We therefore recommend that Treasury includes an enabling provision for incentivized whistleblowing in the bill, even if details of that system and its safeguards are outlined in subsequent policy and regulations. This move would be in line with the Zondo Commission recommendations. Now, your reply there is that whistleblowing is a matter to be attended with the Justice Department, and as indicated, they already published a paper. Right, so you forwarded that to us, NP, and we forwarded it to the committee members. So on whistleblowing, incentivize means that you need to encourage them and ensure that you protect them, I think, and that you might even support them financially. Is that correct, MP?
Yes, Chairperson. I think the proposals from stakeholders is mainly that if there's a successful prosecution of someone following whistleblowing, that the percentage be paid to the whistleblower. So that was the gist of what was proposed in, well, it was also in NETLAC, the proposal was made and by the stakeholders. But I think now from JSR, they're proposing an enabling clause in the procurement bill. In the discussion paper from Justice, there are proposed amendments. The one is a provision for a fund to provide for protection of whistleblowers. And just to add, in our consultations in the public hearings in provinces, the concern there was it's not about paying people, they need protection. That was the argument. So I think the whole issue of whether there should be payment of a whistleblower, should there be successful prosecution, is still an issue that should be debated and not necessarily be written into law in our view.
Okay, so on the side of the MPs, what do we think about whistleblowing? Should it be in this bill or left to the Justice bill or what? We discussed this last week and came to a tentative view, but now we have to move towards. You see, what we are doing here, comrades, and colleagues, we taking policy decisions. Some are clear, and Esther's done a wonderful report with her team, by the way, an overview. I asked her for a page, just noting what's in the report, but she's done about 6, and it's very well done. We'll put it all together and send it to you, right? So we are signaling what our policy is, and then we're going to ask them to start drafting it and then take final decisions. Right, over then to anybody who wants to speak. Let's see.
I have this option.
Oh, sorry. Yes, please do. Wonderful, wonderful. Go ahead.
Chair, I think we must not find ourselves taking decisions or overstepping our mandate. Correctly said by your good self. Maybe the issue of the decision, what should be done to whistleblowers in terms of remuneration or incentivizing them. Let's leave it to, or let's refer it to Justice Committee as the relevant committee to decide on that, because my understanding is that we are talking about justice and we are talking about active citizenry, where people should not leave or should not look away when they see corruption being done. We encourage that, but at the same time, we also understand that when you blow the whistle, you're also risking on your life. So it can't be about money, but it must be about commitment and wanting to see justice done and rooting out the corruption. Whilst one appreciate what has happened with the Zondo Commission, it has outrooted some of the things that we were not aware of, and we appreciate the whistleblowers who were able to come out on the public or to expose those who were doing corruption. We really support it, and I think this is one of our resolution as the ANC that we've taken. So it's a good thing that whistleblowers must be encouraged to blow the whistle where they see corruption, and justice must prevail. But they must also be protected. I'm not sure about incentivizing, because now we are encouraging people to do this. Sometimes you do something with good intentions, then you get unintended consequences, whereby people will be seeing this as a money-making scheme. And where do we get money to do that? But I think the relevant committee that can do that is just this portfolio committee or select committee. Thank you, Chair.
Thank you, Dikeledi. Dennis, you got your hand up?
Yeah, morning, Chair. Morning, everybody.
Morning.
Yeah, I see you more than I see my spouse. Chair, yeah, I think we've, I'm not going to add a huge amount to the discussion because I do believe that this does rest quite firmly in Justice's space. However, one cannot totally remove the procurement and the need for the procurement issue and remove it entirely from the need to open space for whistleblowing or people to be able to raise their issues. So, Chair, I don't think it's our space to demand or whatever a review of the legislation. I do, however, think it might be useful for the Chair on behalf of the committee, and I mean, I'm reluctant to give you a task, but it's a suggestion, Chair, that the Chair could write to the Chair of the Justice Portfolio Committee in the 7th Parliament to say, this has been raised, and I think we all agree that there is a need for it, and perhaps that the inputs that have been given in these meetings should be taken into account. Because I think we've gone into it in reasonable detail in the process. So yeah, just highlighting the fact that these discussions have been had, and perhaps drawing attention to the fact. Again, Chair, I'm not sure if a letter from one chair to another is sufficient, or if it would need to go to the ministry. That's outside of my knowledge. Thank you.
Yeah, no, thanks. Both have been very helpful, Dikeledi and yourself. I share the views. I think I will do what you say. I can even send it to members to look at and comment. I will send it both to the chairs of NCOP and NA, and we'll also send it to the minister. No problem. We'll do that. When we come to the conclusion of this process, we'll do that. No problem. Secondly, what you and Dikeledi can think about, and maybe Treasury can think about, is can't we just have nothing about incentivized whistleblowing? What I like is what you seem to be saying, which is instead of a percentage, as Dikeledi says, then somebody will make accusations and be a pretend whistleblower and all that. But I think what we're also saying is that, as Dikeledi is, you know what? It's not fair. As I mentioned, 2 examples of those 2 women, right? They were completely abandoned, even by the private sector. So this fund that you speak of, that we must support. So in the report, Esther, what we can say is that, what Dennis and Dikeledi are saying in a few lines, that, of course, we agree that, Dikeledi's point that, whistleblowing is utterly important, and, people show bravery, and they not often say they can't be abandoned. Many of them lose income and suffer other things like threats. Put all that down and then capture that, and then that will become a paragraph that we can, agree to, and then we send that also as a text from our report to Parliament on this matter. So on incentivized whistleblowing, just some information I wanted to ask. Is that agreeable, by the way? That's the approach we take. We ask for a clause that's a generic one, which simply says that whistleblowers should be, we'll find a word, MP, that's reasonably consistent with the Justice policy discussion paper. You can choose their words and so on without doing anything more. We won't mention incentivized, just whistleblowing and so on, right? So MP, can you draft a clause in the bill which refers simply to the Justice Committee's work or existing. I don't know. You'll find the way of doing it. Can you do that, MP and Willie?
Yes, Chair.
Right. Then let the members decide. It's just a draft. Remember, all your drafts will be subject to consideration, but we're consistent with Article and Dennis is saying, right? And then Esther and I will work on the text of our report, and then we'll do what you're saying, Dennis. Okay, good. That's helpful. So we're not coming back to whistleblowing, incentivize whistleblowing. At least we've taken a position. That is now a final policy position, unless we change our mind. It's not final. It's our current one. And then when we look at the text, that's where we make the final decision on it. Okay, so moving on to Procurement Reform Working Group, the new chapter restricts participation in procurement from the outset, right? It does not even mention price, which is highly unusual internationally. And your response is there. The regulations will detail how the framework must be implemented. It's proposed that clause 21.5.1 be amended to contain a general requirement on bid evaluation as prescribed by regulation as part of the framework of an instance. Now, can you explain that simply, please? I think I know what you're saying in simple language.
Sorry, Chair. Yes, that's the clause that we dealt with yesterday. That would include the different elements, for instance, price, functionality, and other requirements. So we didn't put it in this report. So that's what that would deal with that aspect.
Yeah, so we've covered that. So what you said yesterday, so it does include your point, Dennis. But in a way, we said that doesn't preclude emerging unable to deliver the same low prices as established businesses, right? In other words, it's one of several criteria, but it certainly can't be excluded, right? Okay. Now, the NA is going to complain, right? Because they didn't want that, right? So that is why we should couch it in a way, I don't know how you do it, you the legal drafters, that makes their concerns. You see, it's no use now not taking into account what the NA has done, right? Because they thought this thing through and that's what they wanted. So, this is like, it's important that we keep them also because we need them to accept what we're doing. So we say something that takes into account their concern, but without, blah, blah, blah. I'm not going to cover that. Okay, any comments on this one? Because we've covered this, right? So let's move on. We don't want to repeat it because, you see, normally, as you know, MP, when we get tables from you and all the departments, we don't do it. I understand why you did it like this. We don't do it by organization. We take themes. We say incentivize whistleblowing. JSR said it. So-and-so said it. PUSA said it. Issue of confusion between develop and implement. These organize. So we have themes. It's faster to do it like that. But never mind. Let's do it like this. In fact, the stakeholders will find this a better system because we have to look at everyone. It takes long, but we are doing it, right? So the next one then is serious issues about Chapter 4 aligns with the rest of the. Okay, we know this one. The bill establishes two frameworks, one in Chapter 4 and another in Chapter 5. These frameworks deal with overlapping subject matters. But Chapter 4 now entrenches a series of procedural steps inappropriate to statute, and so as various points interferes with Chapter 5's objective of creating a flexible strategic. Right. On that one, can you explain your response? I did read Chapter 4 and 5 again yesterday. I'll tell you what my response is, but anyway, you go ahead.
Firstly, Chapter 4 prescribed the framework that 2173 of the Constitution require for preferential procurement. And then Chapter 5, well, the rest of the bill deals with general procurement requirements. And I think the specific clause that I refer to is 25 that says the minister must set a framework for the procurement system. Now, the preferential procurement framework exists within that procurement system. So it can't, strictly speaking, I don't think one can say it's different frameworks. And the end of, I think our point is it's still one law that deals with procurement. And then on the procedural aspects that they mention, they say several. I don't think there's that many, but there are ones in 75 A to C, and this is actually a theme that recurs or a comment from several stakeholders that this should not be in the bill, some for different reasons, and put by by the working group. And we are proposing that it be omitted, and that the clause simply reads that bids under on clause 17, which the set-asides must be evaluated according to the prescribed criteria. So that's the proposal that we are making as an amendment.
Yeah, it helps if you got the bill side by side with you. Okay. I don't know if that fully addresses the concerns, but we will come back to that. Anybody want to say anything? Not anybody on the mobile side? Sorry, it's my reflux troubling me here. So, what I think, comrades, is that, and colleagues, is that I looked at chapter 4 and chapter 5, taking into account the view that it's a duplication and at times an inconsistency. And I couldn't see it, but, I wondered if, we had more time, whether we can't make it a bit more elegant. There is some senses in which it can be slightly confusing. So, at this stage, I think we should leave it, but it's another thing that we should look into our report in phase 2. We're calling this phase 1 of the bill. At this stage, if we get to finishing it, phase 1 of the bill. In phase 2, they need to look at the need to simplify chapters 4 and 5 and the relationship between them. In a bill, you can't, put a context. I was one of the people who argued it. By the way, MP, you'll shudder to think this, right? I got defeated repeatedly. But we argued that people who are going to read this bill, municipal systems bill and municipal structures bill, are not necessarily formally educated, and it's a too long bill. And can't you, after a clause, explain the context? And all of you almost died, you lawyer drafters. What was the other lawyer that we had, the one brilliant guy that your external guy used to use? Yeah, he's a brilliant drafter. By the way, colleagues, I read the Constitution again yesterday, not just 216 and 217. It's beautifully written there. I must say, the simplicity of the language, the clarity of the structure. It's a marvelous Constitution, really. That's the first group of MPs and advisors. And Willie Hofmeyr was one of the people. I'm sorry to bore you with history, but it's a beautiful Constitution, really. It's so well written. And Willie Hofmeyr and them, what's that thing calling me? Drafting made simple. What was it? That big thing he was running in Parliament.
Plain language draft. Plain language
drafting. And it's a marvelous example. I'm not the only one who thinks it. We have been to other countries, and other countries have visited us. The Swedes were enthralled when they came here in around 2000, 2001. They thought it's brilliantly written. Anyway, and the Germans, by the way, whom we often had around up and down. When we went there once, they said, man, your Constitution. But anyway, we should be proud of some things, Dennis. Read that. I'm sure you read the Constitution in the last few days. Isn't it beautifully and simply written? It's a great tribute to that first lot of MPs. I'm not talking about myself. I had a very marginal role. So I'm talking about others. Okay, let's go on. We're moving on to saying that this matter needs to be looked at in phase 2, really. So the next issue then is, MP, can you faster than I am, because you know this document better. Can you quickly summarize what they're saying and then your response, and then members want to contribute? There's some things we don't need to contribute on because we've covered it in different ways.
Okay, sure.
Yeah,
so I just want to add on the previous one, there is that new 25(1)(d) that we are proposing, which I think would help with the synergy between chapter 4 and 5. The one on including the matters to be used when you evaluate the bid. Then the next point is in the bill that was tabled, there was a
Can you pause there? When you're saying the addition will make it clearer, the relationship between the two chapters, right? Just explain that again and just direct us to which page and where it is.
Sorry, it's not. It's that clause that it's on the previous page under 2.2, where the response to the comment on the new chapter 4 from the procurement reform group, where we said we propose that 25.1 be amended to include the general requirement on bid evaluation. So that we make clear that bids that are submitted that's subject to chapter 4, the evaluation thereof will be regulated as part of the procurement system that is in clause 25, which is in chapter 5.
All right. Okay.
Yeah.
Okay. Yeah. All right. I'll look at it more carefully. I'm sure others will. Okay. The next point then, please.
Okay, the next point is that in the table bill, there was a power for the procurement office and provincial treasuries to review the procurement policies of procuring institutions. Now, they say that is an important function for a coherent procurement regime, and they requested to be reintroduced. Now, what is contained still in the bill, which is before the committee, is that the procurement office may issue a model policy which could be for different categories of procurement or types of procurement or procuring institutions. And then this can be customized by each institution for their own requirements. So it's not that they must implement it, they can adapt it according to the requirements. And we think that's better aligned to what we're indicating, that it's for the accounting officer or authority to make decisions and determine its own policy on procurement. And that we shouldn't introduce this review function for the procurement office. And obviously it will require additional capacity if there is such a power for the procurement office to do so, and provincial treasuries. So we instead say it should suffice that model policies may be developed by the procurement office.
But they're not binding, right?
No, they're not binding.
So what's the problem then? If they're not binding, it's fine.
Yeah, so I think what they requested is that there was a power in the table bill that the procurement office must review the policies of procuring institutions.
All right, so you've dropped that, right?
Yes.
You've dropped that. Okay, fine.
Yes.
Okay, in that case, I think you're fine. I think we should just do this. Dennis?
Yeah, thanks very much, Chair. Sorry, I'm in my office in the Marx building, and the light behind me is very bright, so I'm not turning my camera on.
Okay.
But yeah, so I just want to explore this a little bit. To what level are we looking at, allowing a certain amount of power? Are we talking here about state-owned enterprises only? Are we talking here about devolving certain provinces powers down to provinces, down to municipal level? What about municipal entities? Are we looking at giving a fairly wide degree of flexibility in terms of this, or will there be certain areas that are more restricted? And is that going to be managed through the regulations? I'm trying to get my head around this, and yeah, perhaps a little bit more coloring in from Treasury, please.
That's fair. MP?
My hand is up before MP, Chair.
Oh, sorry. Nkululeko, can you please help me? Thanks, Dikeledi. Please do come in. Sure.
Yeah, Chair, I just want some clarity, and you'll pardon me for my ignorance. If
No. Listen, comrades. Can you clarify something, colleagues? There's no such thing, right? Can I just say something? I want to say something. I meant to say it, but because I was late. I want to say that since 1998, I cannot recall a more challenging bill that I've been chair of that, well, at least for myself, had to process, right? It's a very difficult bill. Now, MP and Willie, they're immersed in this bill for 10 years. And you're experts. One of you is a legal drafter. And I'm pleading with MP in particular, but everybody, including me and those of us who speak English and have certain advantages in formal education. It is not fair, the language we use, including me. And I think it disadvantages those of us who are not English speaking, And those of us who came to Parliament without being in a provincial legislature or sometimes even in a municipality and came to finance, the worst committee you can be in because of the requirements for technicalities. And we need to encourage them to speak. And I want to say, when we had a study group meeting yesterday, a lot of good things came out. And it's very clear that people know more about what's going on in this bill than might seem to be the case. And that we don't facilitate it as chairs, this participation. And, you know, I just think that as a chair, I want to apologize for not creating more space for those of us who come into finance from nowhere. I can tell you, I'm saying this because it's about participation and about fairness for those of us who are, let's say, elites here, because we're formally educated and we have been in Parliament since 94 and we speak English. And that's our first language. So, MP, you speak Afrikaans, presumably. So it's not easy. But I think you speak a bit too fast, really. And I'll be very grateful. I know it's not easy because you're a technician, okay? To speak in simpler language. Dennis and I will also. And to come to the point, nobody needs to apologize for anything that they have to say. This is Parliament. They have the right to ask what they want. People can say, please, can you repeat? What is Section 2171, right? Not everybody has the facility to access the Constitution on the website, so not so fast, right? As some of us might be. So at this juncture, I want to say nobody needs to apologize for any question. And it's interesting what Dennis says. Look at what Dennis says. Dennis says, we're all ignorant on this. So let's not use words like ignorant. Declare, I know you mean well and you're being honest, which is rare for a politician, but there's no such thing. I'm also ignorant, frankly. I don't know what she's saying, really. I have to read it again. Okay, thank you. Sorry, Declare, to make a long speech. I meant to do this in an introduction. And somehow, you know, I came in and flustered because I couldn't even connect with my iPad, but now it's working. Sorry, Declare, no more long speeches from me. We need to move on. Oh, Declare, where are you now? You got so bored with me, you shut off. You shut off. Where's Declare? Where's Declare?
Am I audible? Yes.
Yeah, good. You're back. You heard me, right?
I wanted to say, Chair,
Yeah.
this office, procurement office, when it was introduced in the 5th Parliament, we were very excited, and as it was presented to us by Treasury, we were excited, and we saw that this is going to help us to deal with what we've been struggling about, the issue of the value for money, because money is being spent, but we don't see the value that has been spent in terms of the service delivery, and also to deal with the pricing. You know, we were happy. We thought this is going to help if it's centralized. But I don't know from what MP is saying, or all of us, or this bill, what it's saying is that we are taking those powers, or we are minimizing those powers from that office in Treasury. What is it? And if we are minimizing or we are reducing those powers, is it because we had trust in the person who was heading that office then, that he's going to do well? Was what informed the decision, and what informs the decision now, the action that we want to take? Thanks, Chair.
Yeah, you know, I didn't think of that. It's a very interesting question, right? Can I just seek some clarity as well when you answer Declare's question? Is this the one that Kenneth Brown was originally chairing? Is this the same one, MP?
Yes, Chairperson. And it's now...
and it's always been in Treasury. Oh,
yes.
Yeah.
Yeah.
Now, sorry?
It's just a different name now, because it's currently called the Office of the Chief Procurement Officer.
Okay. Now, please answer Declare's question.
Yeah, so the proposal is that this public procurement office will basically be the successor of this office, still in Treasury. I think one of the main differences is because this office and the head of that office operates under delegations from the minister from the
right.
to the
Yeah,
DG,
yeah.
and then while this bill will now give a certain original powers to
Yes, yes.
the procurement office. So I think that's one of the main differences. But the way we see it will be a successor to the OCPO as we know it. Mr. Matabula and some other colleagues on the platform are in that division called the Chief Procurement Office. Then on Mr.
Is Willie here today?
He
Sorry.
is, but he
Okay,
is.
go ahead.
I'm sure he can
I'm
speak,
here.
but he's not
I'm
here.
here,
Oh.
Chair. I'm here. Good
Okay.
morning, Chair. Yeah.
Are you feeling okay?
Well, I'm getting there, but I'm on medication,
All
Chair.
right.
But I am.
Okay.
Yeah.
We wish you well. We wish you well. Yeah.
All right.
Okay.
Can
Sorry.
I think
Chair,
to
can I-
Mr.
can I-
Ryder's
can I-
question? Sorry.
Can I just respond, Chair,
Mm.
on the question of probably maybe raised by Honorable Masang and then also by Honorable Ryder. Look, what we're saying, there are almost 1,000 government institutions who, have to develop their own procurement policies. And then, but what the PPO will do, the Public Procurement Office will do, which is a point that we're making, the Public Procurement Office, we're saying, may develop that model policies. And then, so that all institutions then can take on that model policies and customize their own policies, in respect of the dynamics of their own institutions. But at least they should be a model policy. Now, the provision that was originally there in the table bill was that the Public Procurement Office will develop those policies. Now you're playing two roles. You're playing a role of an oversight role, and at the same time, you also seem to be a player in the game. So, and also given the variety of government institutions in their different shapes and forms. So that's basically what we're saying. Now we're saying at least the model policy will be there, but institutions will take that and convert it. In fact, this is also in keeping with our proposal in clause 16, where we're saying at least procuring institutions will develop and implement. At least this is what we're proposing now. Say a model policy will be there, but institutions will take that model policies and then, of course, customize it to their own environment. Not that we are disowning the oversight role. Will still play that role. That office must still play the oversight role in terms of what happens in institutions. And by the way, it's not only an oversight role, but also a support function, because that's what we need to do in office, to say, to provide support where institutions may be picking up problems and so on. So that office should provide that guidance and support. That's basically the answer to the question, Chair. Thank you very much.
MP, you want to add anything?
Yeah, I thought we must just maybe take, given Mr. Ryder's question, a step back to start off by the procurement system, which the minister must prescribe a framework, and then each institution must develop their own system in line with that framework, and that system must include the procurement policy. And then we propose that clarity that Mr. Matabula referred to, that they will implement and develop and implement that policy. And that is for each institution to determine on its own. But then also on the model policy, the current provisions say the procurement office may issue a model policy, and if that is issued, it can be used to adapt to their own circumstances.
All right, can we then ask a subsequent question? Does this mean you have to empower the PPO through more staff and resources? Because what you're saying is that it's basically got an expanded role. It continues to do its old role, but also this role. Is that correct?
the provision is discretionary, opposite, but if they're going to start doing that work on developing model policies, but I can't speak for them, but it may require additional capacity for them
I
to
would think
do
so.
Yeah.
I would think so. Okay, but we must note that, Esther, that there's an expanded role for the PPO, and it seems to us that Treasury needs to seriously consider providing it with the necessary resources, even though I know there are some things that may, not must, right? Dikeledi, do you want to come back on this, or you okay with it, or what?
I'm fine, Chair.
Okay, the other trivial thing, but important thing. You see, when the office, she's right, I didn't think about it, Dikeledi, you're absolutely right. You know, when the office was formed, and then soon after, or not too long after, Kenneth Brown was appointed, right? He was often in the media. Like the office had some sort of, like, a public domain role. Okay, we knew about it, right? He was often in the media. But in the current situation, I don't even know who the CEO is. Who is the CEO? MB, Willie, who's the CEO? I won't trouble you, Willie, because you're not well, right? So
Yes.
you'll come in when you want to. So who wants to answer the question? Who's the CEO?
Sorry. Yeah, the Chief Procurement Office is Mendo Ntswalalana, which I think he's currently on leave, Chair.
Oh. But all I want to say is that, I don't know if it's correct for me to say this, right? So it's a tentative point. Given the increasing levels of corruption, if more people knew there's this office, I know it's not the police and the NPA and all that, maybe they'll be slightly more wary. I don't know, but we can't prescribe about this. But I'm just saying, obviously, people are very different personalities, okay? And doesn't mean because a person's not in the media every day, they're not doing something. On the other hand, if you're in the media every day, you're probably not doing enough and so on. I'm not suggesting Kenneth wasn't, but okay, let's move on. The next point then, can you take us through it and you'll be faster?
Okay, the concern that was raised
What page
that
are we
is,
in? Always tell us.
sorry,
Always
it's
tell
on
us what
page
page.
6, paragraph 4.
Yeah. Tensions within section 30.
Yes, because the concern is the distinction between section 30 that deals with ICT-based procurement, and then clause 25, which deals with the procurement system, and section 33 that deals with transparency. Now 30 is a provision that provides for, maybe I should explain it, then they say it creates a parallel process for expanding procurement methods and transparency, and should be aligned to section 25 and 33. Now, what is contained in clause 30 is a requirement for the PPO over time to build the ICT-based procurement system, and that is a tool to implement the procurement system. It's not a parallel system. So that system will then be available for use by procuring institutions to facilitate procurement. And then also it have requirements regarding access by both bidders, suppliers, and obviously procuring institutions and the public, so that they can follow a procurement process from start to end. And then that, but as I indicated, that system is to be developed over time, and there's a requirement to have a design process for the system before it's implemented. I think that's one of the, well, it's not the issue here, that this will definitely have cost implications. And that's also why we're not saying it should be have it in place immediately, because it will take time to build it. Obviously, the CPD currently, this central data, sorry, I've got the wrong name now, is already a starting block for that system. So the procurement working group made some proposals to amend clause 30. And some of these we do support those for consideration by the committee, and also to align maybe with 25, that we talk about procurement procedures and processes as proposed, but not use the word central, because institutions will still have their own procedures and processes. And then there's also a proposal that we, because it provides for a marketplace, that we talk about electronic marketplace that could be used for procurement. Sorry, thank you.
Right. Yeah, no, that seems fair to me, but I can't decide for everybody. So if there's any objection, I think we should agree to this. But you know what puzzles me repeatedly, Willie and MP, is why do sophisticated, technocratic elites who know law seem to constantly misunderstand what you're saying, right? Now, here you've conceded that you have to do something, but that's the thing that struck me yesterday, looking at the bill and looking at your responses again. It puzzles me, really. So that's why I'm a bit cautious about some of the things you say, not because you're misleading us, Treasury, but I mean, constantly it seems as if people are misunderstanding. Even when you're conceding to some of the things, there are other things you don't concede to. But I mean, these are people who've been with this bill since NEDLAC days, you know? So I am puzzled, really. I haven't come across this sort of thing before, which is why I'm a bit cautious that maybe there's more to what they say than we understand. And that, you know, in your summaries, you're conveying to us. I'm not saying wittingly. I'm just not questioning your integrity either of you. I'm just saying, okay, fine, let's move on. I think what you're doing is fine here. So nobody seems to disagree, so you go ahead. All right, so we're not coming back to that. Okay, so Esther will remember that, and so we're not coming back to that. So then we move down to page 6, we're at paragraph 5 now, on beneficial ownership. But we covered this, haven't we, in discussions?
Yes.
That you now, just give us your response. Colleagues, we've covered this, really, on beneficial ownership. Yeah, go ahead,
the point made by them and also other stakeholders that the reference we made to the Companies Act is not the correct reference. And we agreed that it should refer to 5614 of the Companies Act. When we deal with beneficial ownership.
Yeah, we don't need to over-explain. That's fine. Next page, paragraph 7, are we?
Yes, this is about the definition
of... No, 6 talks about... doesn't it talk about PAIA?
Yes, that's about confidential information. I can just explain because it's also a recurring theme. I think Kusata also raised this. There's a definition of confidential information. Now, it firstly uses for personal information, it used the definition that's in the Protection of Personal Information Act, and then it lists certain other grounds or matters that will be confidential. Now, initially the proposal was made that we rather refer to the promotion of access to information, because the argument is that that's most closely aligned to, to what kind of information should be protected, while POPIA is more for the processing of personal information and so on. So we support that, but then subsequently they also proposed that why don't we use the Access to Information Act for the entire definition and not use any other grounds, which I think makes sense. So we're proposing that the definition be aligned to any grounds for refusal under the protection of personal information. And that's now...
I mean, that seems straightforward, colleagues. Comrades, Dennis, you want to come in here?
Yeah, Chair, so... The POPI Act is being consistently abused in many areas, and not only by government, by all sorts of entities, where they are trying to deflect or trying to muddy the waters and avoid transparency. And yeah, I just wonder where the POPI Act ends and transparency starts. And, every right has its limitations. And your right to privacy is all good and well until you choose to perhaps engage in certain activities. And I think that when one chooses to contract with the state, and you are effectively becoming a beneficiary of public money. How much protection can you expect from POPI? And I suppose it goes back to the beneficial ownership thing. Chair, I must be honest, I'm thinking aloud here. I don't have a formal position on this, but it's just I've been triggered by what MP's been saying, and I just wonder if it's worth. Yeah, I don't know how to get around it, but the Poppy Act is often being used at the moment as something that people hide behind when they've got something to hide.
Okay. Anybody else would say anything on this matter? Dikeledi, yes, please.
Yeah, Chair, I think I'm on the same page with Honorable Ryder, but differ a bit to say, or maybe to add to what he's saying. It can be either way. It can be abused by formal institutions or government or individuals or certain groupings. It can be abused to negatively impact on one's image, and also looking at the level of the scams that are going around. So it needs to be managed with caution. It needs to be managed with caution and be stricter, so that is not allowed anything about it, because we need to be governed. We need to be guided by our own legislations that we are developing. But at the same time, we must put it behind our minds that the interest will not be the same to all of us as citizens and organizations in the country. Some will be wanting to use those legislations negatively for their own benefit or the benefit of them destroying other people or doing wrong things about that. That's my input, Chair. Thanks.
Yeah, I agree with both of you. I also think that, I think Dikeledi is nuanced, my view, but basically what has struck me before is exactly what Dennis is saying, which is that there are people who do horrible things and they hide behind Poppy. That can't be allowed. That wasn't the reason for Poppy. And Dikeledi is right. There are also people who use Poppy in the reverse direction to do horrible things. So I think they're both right. But obviously, this is an issue that falls under justice. It's something that's interesting, and I'm glad the two colleagues raised it. But what I wanted to ask MP is, if you refer to PAIA, that covers everything, doesn't it? Unless you're saying something specific, Dennis, about what you think should be used beyond Treasury's response, it should be PAIA, because it's all encompassing. But you can come back to us. It's not fair to ask you to make an amendment now, but you're free to do so, and let's look at it and decide. Dennis, are you going to propose an amendment here?
No, Chair. As I say, it was pretty much thinking aloud, and it was triggered by another comment. And one needs to balance the fact. A couple of years ago, the Companies Act was amended to state that directors and shareholders' details, or sorry, not shareholders, directors' details needed to be clearly displayed on the bottom of the letterhead, etc., etc. And now I'm wondering how much impact Poppy has had on that. It hasn't been tested, I can tell you that now, but it just becomes more and more interesting, and the extent with which Poppy has been implemented actually has more impact than I initially understood. And I think we're seeing, Dikeledi was talking just now about unintended consequences, and it was part of our discussion yesterday as well. Just me thinking aloud. I'm not asking for an amendment at this stage.
No, that's what I thought you were doing, but I thought we want to say something then. All right, in that case, then we agree with this thing. Go ahead and implement the drafting. We have asked, I've asked Treasury offline, because I think this should be done, because we need to send this final bill to stakeholders to comment on. But we will write them a letter. I just don't think I've got time. It's probably going to be on Sunday evening. And I don't know what Frank was asked to do something by Wednesday night, but he's also very busy. But you see, colleagues, while we're at it, some of the stakeholders want to overhaul the bill. So we will write them a carefully crafted letter to say we will give you, and they can't argue because we're in committee session, like we've always done on every bill. But we allow people to comment in writing, right? So we will be clear. You can't tell us we gave you too limited time. You're familiar with this bill, stakeholders? I don't think we can give more than 48 hours to look at the bill, and they'll be restricted. You must just make concrete comments and a few lines of explanation. So we'll give them the entire bill. So that means also that Treasury needs to start drafting, because by next week, remember, as we get through this document, it'll get faster because it's repetitive, right? So the first part is slow, but then you will find a lot of the issues are covered later down. So I'm just alerting you that, and if there are stakeholders on the platform, they need to know, we don't want to hear, oh, we were given only 48 hours. In the letter, we'll make that clear. You can't give them more than 48 hours. They can have the whole bill. But maybe what we could do is send tranches of it that we've approved, and then all we want to know is what do they think about it. And we'll come back to it and say, okay, sometimes they're right, sometimes they're wrong, sometimes it doesn't belong here. So having said that, I'm just saying that I hope Treasury is starting to draft, and you have the weekend ahead of you and so on, because the bill ultimately is what it is in words. And that's a lot of work. So I take it you're doing that. Okay, next point is, what is it? MP, can you go ahead, please?
It's paragraph 7 on page 7.
7, yeah.
The Procurement Reform Working Group, they submitted proposed amendments to Chapter 4, which are similar to those submitted by COSATU and SACTU. Chairperson, I don't know whether it's going to be useful, because there are in other stakeholders also proposed changes, some of which we are supporting. Whether we shouldn't, if that's meet the committees, if it's fine, that we in a separate document list all the proposed amendments, and well, maybe also the points raised by the stakeholders, and present that on Friday, unless you think we should do it now, because it's going to be quite piecemeal now, because it deals with some proposed amendments to Chapter 4.
Yeah, okay. Just another point I need to inform the committee. As I understand it, Willie, your team will be ready to take us through the BBBEE statistics tomorrow at 2 o'clock, right?
Yeah, yes, Chair, that's it.
Right. So tomorrow we're going to start with that, because we need to know concretely what the picture is, because we're working slightly in the abstract, although it's not going to substantially change clauses. It just gives people a sense. And we're not going to have an endless discussion about terms and criteria. We just want an overall picture. Poppy is not well. And if she's not available tomorrow, maybe Esther can do it, or we can get her to reply on Tuesday, not reply, to do her side on Tuesday. But I just want some clarity before members comment, if they care to, which is, what are you saying now? We must stop this process and then start another way, which is faster.
Sorry, Chairperson, I just thought all comments that relate to Chapter 4 on preferential procurement, because most of the proposals that's even in this document relates to Chapter 4. There are still some that's not related to it.
Okay, that will help, but I think we can, what's it now, page 7? We are moving rather slow, but you see, when you go through this document, you don't have to repeat what some other organization has said that has already been said by a previous one. Just say this issue is the same as the one there and so on. I don't see why we can't finish this whole thing by tomorrow. So the first item tomorrow will be the statistics. The second item is finishing this document. The third item will be starting with your document. Is that okay?
Sorry, which the Chapter 4 document?
Yeah, the new document. Let's call it the new document, right?
Okay,
so
sure.
Let's
yes.
finish the document we're in, because as I said, once you come to a lot of things you can skip because it's raised by previous people, right? So the question I'm saying is, what do you think first before we ask members? If we try to finish as much as we can today, right, then what we do is tomorrow, I think let's maybe finish this document, then, or whatever members said, or we look at the statistics. Maybe we look at the statistics first. Let's look at the concrete situation first. We finish this document. I'm sure we'll go beyond halfway. In fact, more than halfway today. And then we look at your document, new document. So 3 things on the agenda tomorrow. Are you following me?
Yes, no, I understand. Yeah,
Right.
thanks.
But let's go through, we don't miss anything. And the
Okay, no.
stakeholders know that we've taken them seriously. We're not here to impress them. We're doing what we normally do, except that this bill is the most difficult bill we've dealt with since at least 2014, even before. So what I'm saying is, and it's a torturous process because, ideally, as you know, we just have a table. These are the issues raised by so-and-so. But because of the nature of their concerns and because they wanted more consultation, because I want to return it to NEDLAC, I thought, you know what? This format of this report is fine. Let's move on to the next issue, please.
Okay, the next
sorry.
issue
Is there anybody who wants to suggest a different approach up to 5 o'clock tomorrow?
We agree, Chair, with your approach.
Good. Thanks. I mean, you can always change the approach. I don't know how to go. I mean, that's the way I think, but maybe there's a better system somewhere. If somebody thinks of it, they must raise it with me privately or by tomorrow. Right, let's move on faster now because I'm blabbering. What's the next issue?
from the working group, they proposed amendments to chapter
What page,
4.
what paragraph?
It's paragraph 7 on page 7.
Yeah, the bottom, yeah.
In the middle of the page. It's the
Yeah, okay,
proposed
sorry, yeah.
amendments they made to chapter 4. And we indicating the provisions that we agree to be, the proposed amendments. It's several clauses refer to complementary goals, which is currently
Yeah, I
not
see you removed
defined.
that, eh? Yeah.
Yeah. And then we also
What did you mean by that, complementary goals? But why do you use that term?
We thought that was an additional way of introducing further, I'm going to call it preference methods, or not methods, additional preferences. I don't know if Willie can help me.
Yeah, can you explain simply, what are you saying, really? I saw it in the bill yesterday, reading through it again. And it struck me to the right. Well, what does it actually mean, complementary goals? There's no definition of it anywhere in the bill. Why do you put it there?
No, it's true, Chair.
Billy, in simple language,
Yeah.
what does it mean? What do you have in mind? Concretely.
In simple language, it simply means you apply the preferences that are already covered in chapter 4, but should there be any other preference that an institution may deem necessary to implement, then they can also consider that. That's basically what it means.
But why goals? Goals are aims.
Yeah.
Why the word goals? That's what I'm asking. I know what you're saying, but why do you use the word goals?
Yeah, that's a debate, but I mean, it's a goal would obviously be what else do you want to achieve? That's basically what the reason why I use goals.
All right, let's move on. We're dropping it anyway. Right, good. Okay. Can we move on, MP?
Okay, the next proposed amendment that we support.
Colleagues, can you just interrupt when you can? I can't keep looking at the screen. I'm focusing on this document here. We are 2.3 now, Public Service Accountability Monitor. Is that right?
Okay, so there were some other amendments.
The one, yeah.
Okay, and the paragraph B of paragraph 7 is that in clause 18 that deals with pre-qualification, that it be provided that the prescribed thresholds and conditions also include a prescribed minimum of potentially qualifying suppliers to ensure competition. So I think that is some proposal to align it with the competition requirement in 2171. And then also there was a general
clause 21. Yeah.
Which I think we also, when we responded initially, we proposed that we had concerns about it, that it be removed because it's too open-ended. And then clause 17.5, I already dealt with that. It's removing procedural matters.
We get that. Yeah. So can I ask you a question? Can you please explain pre-qualifications? I understand it now, but just explain to members what is pre-qualification really, as against set-asides and so on.
Chairperson, I don't know. I'll attempt, and then I'll ask Mr. Matabula, can he also, because firstly you have set aside for certain categories of people, and then in clause 18, it's pre-qualification, which would be only apply if you don't apply set asides. Now, it's in our view, it's setting a higher threshold than the one for set asides, and it will. There is a proposal now that we deal with the BE requirement differently than what we have in the bill, or that's in the bill before the committee. That because the first, it would be, sorry, Chair, I'm not explaining it well, but that's the first category. Then the second one we're proposing is that where they subcontract certain categories of bidders, for instance, black people, small businesses, and so on. Or small enterprises where they're owned by black people, or black people who are youth and who are women, and so on. But it's setting a higher threshold than what you would have in clause 17, and then in 19 you will also see subcontracting as a requirement. Jay, well, I think I'm going to leave it to maybe Mr. Matabula.
Yeah, it's sounding very
explain it
torturous.
better. I'm sorry. Apologies.
Willie,
Yeah.
okay. Willie, do you want to explain? Simply.
Yeah, yes, Chair. No, I'm just going to explain by way of an illustration. So, what, for instance, what it means that you would put up a tender, and that tender you specify that this tender is strictly for black youth, as an example. So, meaning everybody that responds has to, of course, comply with that requirement. Could be a black youth, maybe 51% or what have you. Now, any other company that submits a bid and it does not meet that threshold, then it means that company then is disqualified from the process. That's what pre-qualification simply means in simple language. Thank you.
Yeah, I think we all understand that. Yeah, I was going to summarize it more or less like that. Basically, you're saying, for example, okay, you could give a good example. Anybody wants to raise anything there? No. All right, look, then the question arises, under what circumstances will you have pre-qualification? It's correct. Sometimes you say it's only a local business, right, with majority black ownership that can apply. So you can't get somebody from eThekwini to apply in Msunduzi. That's another sort of crude example. But you tell us under what conditions, for example, will pre-qualification apply?
But if you look at 17, that talks about set aside, that's fine. So there's a particular threshold to say you can only set aside. We're going to prescribe a threshold. But beyond that threshold, there's also another threshold for pre-qualification. So there will be a higher threshold for this, for the application of the pre-qualification. So that would be the condition in which you then apply pre-qualification. It's not going to be also an open-ended kind of a system. It will have some checks and balances. Thank you, Chair.
So in other words, I don't know, right? But is this correct to say, I'm asking, if you drop the word threshold, right, can you say criteria? The criteria will be more limited in the case of pre-qualification.
Yes.
Criteria or standard.
That's right.
Yeah,
that's
okay. That's what threshold means, right? Okay, good. Then we go to the next issue. MP, please.
The next would be then paragraph 2.3 PSAM. Their concerns is mainly around transparency. Well, they acknowledge the provisions that we referred to, and also the fact that the one clause was changed from instead of instructions, it would be the regulations, which they say is an improvement. Now, then there are specific comments they make, which is on the next page 8. The first point that they make, they still have the view that the disclosure requirements should be in the bill, and it shouldn't be the minister making regulations about these requirements. Now, our view is that if you look at clause 33, it's not giving a discretion to the minister to make regulations. It says the minister must make regulations regarding disclosure of procurement information and what the regulations must contain as a minimum. And then again, we refer to the provisions in clause 64 that regarding the process to be followed in the development of regulations, which enables a transparent process for stakeholders to to provide comments on the regulations, and also to the consultation report must also be published. So I think our point is that the minister doesn't have a choice. He will have to make regulations, and the bill clearly sets out what that regulations must contain. So that's our response to that, number 1 on page 8.
Now let's pause there. Any comments, questions here? Okay, Nkululeko, you'll help me, right? If I don't notice a hand. And please just butt in, man. Just say what you want to say. You don't put your hand up formally. Okay, so yeah, I just want to ask you, why won't you put it in the bill? Listen, man, I want to say, Willie, I'm reading the bill more carefully now. I just read it quickly, on the first day. But now I read it for meaning, right? And I must tell you, Willie, MP, maybe I'm wrong, but this bill is given everywhere, prescribed. I've ringed it, because I have a printed text. I don't know, except in like legislation that deals with framework legislation nationally for local government, where the minister then had, and I don't want to go into the history, I've covered that, right? But what I'm saying is that it is a bit like surprising as to how much is prescribed, how much is in the hands of the minister. So I would like members to think about this. Okay, but the minister must bring things to parliament where it's appropriate, other things they can regulate, etc. But there's a lot of prescription here, a lot of regulation here. Now, I really think, colleagues, we need to persuade Treasury, and finally we'll take the decision. There are times here where, I don't see why you can't just put it in the bill. So, for example, can you give me sort of examples of what disclosure requirements they are wanting? What sort of things they want to put in the bill? We can't have a textbook. We can't have a long bill. What are they wanting really? Give me an example of 3 things they want you to put in the bill. Then let us decide whether we agree with them or not. Hello?
Chair, must I respond? Sorry.
Yeah, that's a question to you. And yeah.
If you look at clause 33, that's where we have the list of information that the minister must prescribe for disclosure. Just as examples.
Right, I'm looking at clause 33, right? Right.
33.2 then specifically.
Yeah, right. 33.2 reads, the regulations envisaged, that's the ones that we're talking about, must, among other things, require the categories of information to be disclosed to enable effective monitoring of procurement, which includes, among others, the reason for the decision, where the decision is made, blah, all information. Oh, I see, Yara, of course. I see you've got a lot here. So what do they want then? I don't understand. It's here, but they don't want the minister to prescribe. They want you to put this down.
Yeah, I think, sorry, the way I can explain it, if you look at the current legal framework that we have for the PFMA, the only thing that the PFMA say, you must have a procurement system in place. All of the requirements of procurement are in treasury regulations and instructions. I'm not saying that's correct, but that's the way it is now. And under the MFMA, there is a chapter on procurement, and then there's a set of regulations on SCM that basically tell a municipality what they should have in their policy. So a lot of the current requirements are not in prime legislation. And I think the argument would be that it needs to be flexible to adapt and so on, and that's why we propose this. And I think it's going to be very difficult to put some of these things.
All
as a
right, I withdraw what
requirement.
I'm saying. Okay,
Yeah.
okay, it's a good argument, right? I forgot about how it's done. I know the MFMA better. But look, let me say something. While all of it is true, right? There are times where what we've done as a compromise is we say these 6 things are there in the bill, and the minister may regulate any further complementary or whatever the word maybe it is, I don't know, or consistent with this subsection. We've done that before, MP, but here I agree with you. I don't know if anybody disagrees. Nobody's got anything to say for now. I agree with you, actually, on reflection. That's a good answer. Okay, can we move on? And then your point is 64 to 4, sub 2 to 4, requires consultation. The minister can't just do what he wants to do, right? That's your point. Yeah. But is it required for the regulation to be tabled in Parliament?
Yes. In 64.
Oh, no. Then you are covered.
Yes.
Yeah. I would like you to alert me, and I'll read the bill carefully this weekend again, where the regulation is not required to be in Parliament. I don't buy this thing, comrades, colleagues, that every little thing the executive must do, they must first bring it to Parliament. And we don't have the energy or time or the skills really to do these things. So I'm not saying that, right? But there are powers given through the bill to the executive, to the minister, that we must say, no, you bring it here. And there's different forms, just to remind those of you who are going to come back to Parliament. There are different ways of putting it. You can couch it to say it must be tabled, that is all. And the committee, if it's got time, will look at it. Or table for response within 30 working days or something like that. That's what we've done in previous bills. But that's for you to think about when you legislate in the next term. Okay, fine, I agree. I don't know if anybody disagrees. The final stage, let us know. For now, can we move on, please?
Okay, I think the next concern they raise, I'm now summarizing, they say that we have existing measures, but the compliance is poor. They don't have access to procurement plans and so on.
Yeah.
So our response is that the current system is mainly transparency is implemented through instructions, which are under the scope of the MFMA. We don't deal with the PFMA. But our view is that if this bill is enacted together with regulation, will provide sufficient compulsory measure for transparency.
Both in the primary and subordinate legislation.
Yes,
okay,
yes.
Any comments on this one? Nope. I'm fine with it. I have some reservations, but I can't summon to my aid what can be done in the circumstances of a bill like this with its complexities and so on. But okay, personally, I accept it. But okay, fine. Let's move on. I can't summon a response, really. I know what I feel, but we'll leave it. The next one, I think we'll all agree with, to the extent they removed. And then you said smaller. Yeah, I mean, who's going to argue with that one? Paragraph 3 there. Do you want to say anything quickly? Short sentences. Don't over-explain, because that's straightforward.
I think the only points we made, you can't expect all institutions to do what in terms of ICT. You have a small museum or a small municipality that's under resource. So
I mean, who's going to argue with that? No, you're right. Okay, it's a bit well, I don't want to say anything about them raising it. Okay, we're getting on to the next page. We're on page 9, paragraph 4 there.
Yeah, this is in the same clause where it's required that the procurement office must determine by instruction requirements regarding ICT for procuring institutions. Now they're proposing that we remove that requirement for instructions. And then they also propose that whatever is issued should be aligned to the national ICT and e-government strategy. Now, the first point that we say, actually, we're proposing now, instead of having instruction that the procurement office must by notice in a gazette determine these requirements so that it's more flexible. But we don't think it's going to be possible to simply leave it without further rules regulating this, simply putting it in the bill. And then secondly, on the proposal about the national e-strategy and also electronic government in the public service, we're proposing that we add provisions to the two relevant acts that deals with these, that whatever the procurement office does must comply with these requirements. And even I think it would apply, but it does no harm in putting it in the bill, in our view.
Any comments here? Nope, I think it's fine. Let's move on. We agree. Frank, also, when it comes to constitutional issues, because we've got some different angles to it, you might want to say one or two things. So anyway, you can just butt in when you want, Frank. Okay, next, please, paragraph 5, I think it is.
Yeah, the next one is they basically made proposals as to the matters to be listed in clause 33 that we looked at now. We in our response, we do support a proposal that we also refer to information about bid cancellations, because that apparently is a problem in practice. That lots of bids are issued and then they cancelled. So we support that proposal, but in our view, the rest of matters listed there under paragraph 5 is sufficiently covered. And then they also propose as to when information should be made available that we should, sorry, I'm now rushing, should be done within 14 days. But we still think that's not going to be practical, because in cases where there's a reconsideration or a review, we should rather keep it as quickly as possible in the bill.
Yeah, okay. Any comments here, colleagues?
Chair, can I just expose my ignorance again for a second? Perhaps if MB can just explain to me the difference between regulations and instructions. So I mean, we've got the two juxtaposed in these last two paragraphs under the discussion. Perhaps, yeah, just a quick one, and I might need to come back after the explanation, please, Chair.
Yeah.
Under the bill, the minister would be the one making the regulations, and there's a particular process prescribed and consult other relevant ministers, and we also propose that organized local government be consulted. And then he must publish the need for the regulations, the likely impact, and so on. And then there's a requirement actually currently for all regulations to be submitted to Parliament for parliamentary scrutiny. And then there's also a requirement subsequent to publish a consultation report reflecting on the consultation that took place and the responses. While instructions are to be issued by the Public Procurement Office, I don't want to oversimplify it, but it's more like administrative matters, and that may be issued or determined by the Public Procurement Office, and for instance, like standard bid documents and so on. So I don't know if that...
No, you covered the ground. No, that's very clear. Dennis, basically, I think you understood her. And instructions have to be within the regulations and the act. Can't be outside it. It's like doing the nitty-gritty of, like she says, forms and so on. Okay, come back, Dennis. You wanted to say something, if need be.
Okay, thank you for that. So, yeah, I mean, I'm a little bit more familiar with the MFMA still than with the PFMA. The MFMA has a requirement, and I'm not sure if it's Section 71 or it's close to Section 71, where there is a monthly disclosure of procurement that has happened outside of the normal processes or emergency procurement, etc., etc. This paragraph seems to be pointing to the fact that disclosure of procurement information, that's quite a broad comment that's coming from PSAN. Is it pointing to similar things? So kind of a monthly disclosure of procurement that has happened outside of the exact normal processes, or is this a more broad call for transparency where the details of every single procurement item get disclosed? I'm not sure I see the intention behind this. Thank you, Chair.
Thank you. Respond,
Maybe
please.
I asked Treasury. We should have asked PSAN.
Yeah. Anyway, no, there's nothing stopping us from writing to them. So if you want, just pose your question and we will send it to them. Yeah, same applies to any stakeholder. They're not here. Right. Reply, please. Do you want to respond, MP?
Yeah, I think their first point was about, does this want disclosure to be a direct obligation in the bill and not through regulations? So I think that's my interpretation
Yeah.
of where they refer to procurement. Because we also in the list in 32A Roman 2 talk about all information regarding a bid. But it's, I think, an important requirement is also we say, sorry, but that's not related to Mr. Ryder's comment. So, yeah, I don't know if that's assist.
Dennis?
Yeah, I'll chew on it, Chair. Thank you.
Yeah, pose a question. We will send it via Nkululeko to them. Okay. You see, what I had thought about, colleagues, is that at times we should call in the stakeholders specifically. You know, it's this area, so and so said this. Let's call the 4 of them and so on. But you know what? It's going to get very messy because some people will complain. Why so and so is being called? I also have the same points, etc. And I just thought, let's drop that. The best thing is just give them the text, because the final thing is the text. They asked for the text. They didn't need to ask for it. They can only ask Nkululeko for it. We've never turned down anybody. But Dennis, if you can think of another way of bringing them in before we even send the text, that's fair. I'm cool. Let's bring it to the committee. But nothing stops us, any member, from saying to Esther, can you draft this thing? Give the thing over the phone to her. She or Poppy will have to do it. And Nkululeko will facilitate a reply. So, you know, we can ask specific questions, Dennis. But I'm satisfied personally. But if you're not happy, cool, let's write to them. Okay, but they mustn't give us 10 pages. We'll tell them it's a 1-pager. Okay, next then, MP, please, let's move on.
2.4, that's the National Research Foundation. I think the first point they raise is about costing. And it's inadequate, the cost implication. I think we did discuss it on Tuesday. I don't know if we should talk about it again.
No, there's no need for it, but what we are going to say in the report, I wonder if we summarize that, and I'm doing it now if I didn't, Esther. Colleagues firstly, they say that socioeconomic assessment report is inadequate. I think we agree, okay? I don't know what you think. And it's naive and characterized. You see, these are extreme words, you know? Extreme words, really. It doesn't inculcate a sense of dialogue amongst parties that are equal. I know I went a bit overboard on Tuesday, as somebody told me, a stakeholder said, look, you know, you give us a tough time. I mean, we understand, but, you know, in your replies, I didn't think about what I was going to say. It was a spontaneous response. But this is the sort of thing that personally, as an individual, I find unnecessary, naive, and characterized by fallacious promises. You know, I don't mind it. I'm a politician. But to engage with young officials, you know, from the height of being a professor expert, no costings provided. You explained all that. I think we are clear. Is there anybody who disagrees? Please come in, because we haven't got time to rediscuss. Our position is we agree that the SEIS is inadequate. That's all we need to say. And that there's more financial implications than is being suggested, and that we think National Treasury should seriously consider, but bearing in mind that you're phasing things in. So we would say something like, we support the view that different sections of this act should be, or bill at the moment, should be implemented at different times, taking into account funding or capacity. You also have to have capacity, maybe people or people who are skilled who are already there, capacity, funding, and other resources, and other requirements. So when you phase the thing, and that's when you'll do it. But it's very hard. I'm sorry, Willie. We don't have to apologize to the Parliament. No, we don't agree with the stuff that, you know, it's not going to have major financial or any No, we don't buy that. Anybody got a problem with that thing in our report? Okay, I'm glad to hear that, because I was going to propose with Frank that he finds a clause in the rules to expel you if you oppose that. But Frank, you don't need to come in. Right. Now, where applicable, the availability of funds. Okay, I just highlighted that, but then move on, please.
Then on page 10, paragraph 2.
Development capacity building, yeah.
Yeah, I think it would just in short raising that there should be capacity building to implement complex procurement and procurement of innovation. Now, there is a clause in the bill that the PBO must guide and support officials and procurement institutions to ensure compliance with the Act through ensuring professional development and training of officials involved in procurement. And then our view that if institutions are operating in a particular sector, then they should ensure specific capacity building. Not mentioned there, there's also provision for provincial treasuries to provide capacity building within provinces. So that's our response to the capacity building issue.
Any comments here? Colleagues? No. Now, in my notes, Treasury, I said glib. The answer is glib, and I'm sorry to say this, but you know what? We have a right to be playing our role. I'm not going to apologize. Now you're going to say, look, Eunice is being rude. And then he said that those people are being rude. I'm saying glib means that, you know, what's the word? What's the meaning of glib? It means like a bit like too general, not sufficiently deep, not sufficiently
Dismissive,
yeah, an element of dismissive. There is something I must say, my friend Willie and MP. You know, I say that these people are like looking down upon all of us, right? I know they think MPs are stupid, right? I mean, a lot of them in the NGOs, but it's fine. That's their right. But you also, somebody said you're dismissive, and I think it's true. I mean, they make a strong case, Willie, and you guys will reply in 3 lines. But anyway, so you're also capable of that, Willie, and your gang. Oh, by the way, MP sent me a very angry, to exaggerate. I'm wrong. There are far more people in their team. I've forgotten MP. You must just mention it now. You sent me a WhatsApp. I thought it's 2 plus 2 plus these 2, 6, but it's actually extra 2, 2, 2. So I think it's 4, 4, and the 2 of them. But anyway, they can come in when they put in report need for capacity building. Yes. So let me suggesting, Esther, team here, our team, Parliament's team, that we put in there that are concerned about the capacity to implement this at all levels. Okay. And I'm not excluding state-owned entities, but everybody, right? And that the capacity of Treasury to implement this major bill. And put in something strong there, Esther, about our concern. And we will want implementation programs, report on progress on implementation every 3 months, or at least 4 times a year. Okay, getting the basics right, setting up a help desk. Right? Carry on, paragraph 3.
Yeah, it's proposing a help desk, and then also there was a concern about the fact that in the bill, it's proposed that both contract management and asset management be part of the procurement system, and that section 25.3, which lists a number of issues that should be part of the procurement system, that clause be removed. We again, I think we reiterate the clause that there is a requirement to provide advice and assistance to procuring systems and the institutions to implement. And the issue of a help desk is operational matters that shouldn't be legislated on, but it could be considered for subordinate legislation. Then I think we did allude to it on Tuesday, is that there's a clause 28 that provides for procuring institutions to establish a procurement function and what it should do, that we rather change that provision to make it a requirement of the procurement institution to do certain things, but where that's functions are performed maybe in different units, so that we don't prescribe that there should be a single unit doing everything that is to be contained in the procurement system. And then we support the view that asset management should be removed from the list, or it's clause 25.3, not 2, because it's not a function that's directly linked to procurement. But as to procurement management, our view is it should be retained, because the lack of proper management is a major concern in many institutions, and we think it should be a matter of emphasis in primary legislation as part of the procurement system. But then whether it's performed by your traditional supply chain unit or by some other unit, it's up to the institution to decide. Thank you.
Okay. Any comments here? No. Okay.
Yeah, Chair, I think I agree that it shouldn't be legislated, but it should certainly be a principle underpinning.
Yeah. Secondly, I think we should put in the report, like supporting the help desk and so on. You don't need to put that in the bill. But it's a good point they're raising. I mean, it's helpful. I don't think, like some of the other points, a bit confusing why it's raised, but this is fine that they raised it. Okay, next point, please. Next paragraph. MP, she disappeared.
Sorry, I forgot to unmute. Sorry, Mr. Chair. Now, my understanding is from a stakeholder that in countries like the US, they have an exemption basically for the procurement of innovation, and we should address impediments to innovation. Now, first of all, in our response, we pointed out that we do the objects clause do recognize innovation. And then in clause 23, which is in chapter 4, there's a specific provision that enables institutions when procuring to provide for measures to advance innovation. And then innovation will obviously be one of will be enabled through unsolicited bids, because it is a procurement method. So that's our response. We don't think that procurement of innovation as such should procurement processes, but unsolicited bids, that kind of procurement method would enable it.
But if it's just if it is exempted, won't that also open the opportunity for corruption?
Yes, no, definitely, Chair.
Yeah, but I mean, we do. The problem with our country is that we don't encourage research and development and innovation much, not enough. So that is a point that is correct. But, I just got not sure about your response. Let's leave that. But for now, we're accepting what you're saying, unless I can come up with something, which I don't think I will. But in my notes, I've got not sure. Well, let me move on. I don't have an answer to this, right? Now, paragraph 5, procuring through another organ of state must be removed.
Yeah, the bill, that's in chapter 5 after clause 25. I have a provision that stating that procurement from another organ of state must be regulated. Now, in our view, the argument is made by the stakeholder, but this will be unconstitutional because it should also be subject to 2171. Now, the points that we are making, these are several state institutions that have been created to serve a particular purpose. And so what we're proposing that through the bill, that if when procurement is needed for a particular service or goods, and there are existing organs of state that could provide that, and then that should be regulated in regulations, and that will also ensure that that fair price is paid and not exorbitant prices by the institution. Now, just to mention a few institutions that's currently set up to provide services within government is the National School of Government, Government Printing Works, Government Technical Advisory Center, the CSIR. And just also to note, currently in the MFMA, it provides that municipalities may contract with another organ of state without complying with SEM prescripts. In our view, clause 26 should be retained so that there could be specific regulations dealing with when services are obtained from another organ of state. Because we also sought advice on this matter from council, and the advice we received quite recently, or maybe not so recent, but earlier this year, is that 217 does apply to procurement from another organ of state. But that, in our views, that we could regulate it, and it should be specifically regulated. Thank you.
Yeah, I'm fine with that. I don't know if anybody's got anything to say. Nobody so far. Okay, can we move on, please?
Sorry, the last one, it relates to the standstill period, which is provided for when there's a reconsideration or a review of a procurement decision. Now, first of all, the comment from the stakeholder is that the period that we put of 1 week is that's going to be too lengthy. And then also, basically, I think to deter people, you know, taking matters on review, is that the 10% deposit must be paid if there's an adverse finding from reconsideration or review. Now, in our view, this 1 week standstill period, sorry, that's what it's not, sorry, that's what they proposed. So I just want to go back. That we need to make adequate time for the reconsideration and the review of a decision to ensure that the matter is heard and addressed in a fair manner. And this may take longer than a week. Sorry, Chair, I just have to go back. I don't know if my colleagues can maybe check. I'm not sure whether the stakeholder is proposing a 1 week, which may be shorter than our period in the bill. If they can maybe just check for me. And then also, in our view, requiring a bidder or unsuccessful bidder to pay a deposit, in our view, may render the process unfair, because some of them may not have the ability to pay such funds in the case of the review, the reconsideration or the review being unsuccessful.
Okay, there's a question from. Why don't you just ask your question, Dennis? What is it?
Yeah, sorry, Chair. It's something that I haven't picked up yet, and I didn't pick up in the discussions earlier. This standstill thing. Where is it covered in the bill? What paragraph or what clause are we dealing with? Because I'm not sure I understand it.
It's clause 55 of the bill.
Thank you. I'm flipping.
Okay. Just explain simply what standstill means.
And award the tender if there's a pending reconsideration or a review. And I note now that the commentator did provide, the stakeholder did propose a 1 week period, where in the bill it's proposing a longer period than that.
Yeah, it says 1 week. Delete this lengthy standstill and do the EU thing, right? But I mean, the EU has got skills and experience and capacity we don't have, right? And then the risk sharing mechanism. I don't actually have a problem with what you're saying, right? But if somebody wants to pose a question to them, the stakeholder, that's fine. But I don't have a problem with what you're saying, right? You know, so many bids are contested. Everybody, well, to exaggerate, so many people who lose out want to contest, right? And take the matter to court and so on. So, yeah, okay, all right. I don't want to say anything more. Can we hear from Dennis? Are you sorted, Dennis?
Yeah, I'm having a look. Yeah, I think it's a case of 10 days has been proposed. I presume that's then 10 working days, which is 2 weeks. We want to reduce it to 1 week. In an ideal world, it would be 24 hours.
Yeah, you're right. Yeah, you're right. Ideal world, 24 hours, I agree. But hey, let's just stick with this, right? Okay, no thank you to the stakeholder. Right, okay. Next things, please. Next paragraph, please.
Chairperson, I'm going to summarize now because the stakeholder raises concern about that our definition of bid and also the committee
Which
system.
paragraph are we at?
Sorry, it's paragraph 7 on page 12.
I'm on it, but I mean, everybody needs to page 12, yes.
Yeah, so now if you look at the definition of bid, we looked and we agree with this point because it would, the way it's written, it may prevent it will prevent unsolicited bids. So we or if the committee agrees, propose an amendment to the definition of bid. And if needs to also look at the definition of bid committee, but that may not be necessary, but we can make a proposal in that regard.
Okay, comments?
Chair, sorry, I want to take us back, and I'm very sorry. So
No, don't apologize. Go ahead.
perhaps, yeah. So it's just the second half of that earlier comment about the 10% deposit. And I see what the stakeholder is trying to get at, saying that it's going to unnecessarily burden service delivery if we have people that want to object to a procurement process. We then have a 1 week or a 10-day standstill process, and it could be merely trying to obstruct the process and try and make a point, etc., etc. And it might be open to abuse. So I understand the Kenyan model of asking for a 10% deposit. I understand it's to get away from having people putting in what do they call it? Just frustrating the processes. I accept Treasury's response that the 10% may be considered unfair because the person objecting may not have that 10% or have the financial resources, and that's part of the principle that we're trying to push here, is that we're trying to open the system up to people that don't necessarily have massive capital resources at their disposal. So I buy that. But I just want to ask one question. If there's an objection from a bidder, an unsuccessful bidder or whatever, and it stalls the process by a week, is there then scope for another bidder afterwards to come and lodge a further complaint and frustrate the process for another week and then another week and another week? Stalingrad tactics is the term we've all learned about recently. Or is there some sort of a restriction that says, there's one window, you raise your concerns within a window. After that, there's a maximum 10-day standstill period. Following that, everyone must make their submissions. It gets adjudicated. We move forward so that we don't have a kind of indefinite delay to procurement, which then stymies service delivery.
Can I come in?
Yeah, sure.
I need. I want to request an explanation, maybe assistance from MP or Willie, in as far as the bid committee that we are talking about on the bill. At what level are we talking about? The bid committee at all levels, or in the procurement office? Maybe to outline more on in terms of the role of this bid committee, because from my experience and what we have heard, there's always been an unfair utilization or interference with bid committees, and trying to change that. I mean, to improve on that, to make sure that we don't have a standing bid committee. You change people. Is it allowed? What is going on? Maybe if they can just help me to understand this thing of bid committees. Thank you.
Thank you. Over to you, MP.
Chairperson, firstly,
Oh,
oh, sorry, I thought I can answer Mr. Ryder's question. Willie, if you can maybe deal with the committee system. In clause 37, there is a provision within which procuring institution or application must be submitted for reconsideration. So there is a period. So there is a like after that they can't submit a request for reconsideration, and there is also for the review process there is a time period set.
Thank you. I appreciate that. I'm answered.
Chair, on the committees, the specification and the bid evaluation committees are ad hoc committees, so they change from time to time. Whereas your bid adjudication committee is a standing committee, but of course it can always be changed from time to time. The procuring institution can decide and say, you are going to be here for 6 months or for a year. After a year, they review that committee. I'm talking now about the adjudication committee. That's what it is. But the other committees, of course, they change. They are not standing committees. The specification and the evaluation committees. Thank you, Chair.
Thank you. You're fine with that, lady?
Yeah, I'm answered, sir. Thank.
Okay. Can we move on, please, MP?
But Chair, then the next one is sorry, we started dealing with that's on the issue of the commentator pointing out that the definition of bid prevents unsolicited bids, in particularly in innovation, if there's an innovative proposal made. So what we are proposing that the definition of bid be amended to address this concern so that it allows unsolicited bids, because it talks about invitation to bids, which doesn't cover unsolicited bids in the bill.
Yeah, that's fine. Anybody have any issue there? Nobody. Let's move on.
Then at the bottom of page 12, paragraph 8, dealing with, say, the powers of are too general, it's undefined and unclear, some concepts are not defined, and for instance mentioning complementary goals, and again the issue of dealing with the principles in 2171.
No, we've said no to that. Let's move
and
on.
so on that. So I think we
But
explained
the powers
what's under
thing,
response,
and
yes, and
complementary goals you've dealt with already, right?
yes.
Okay.
Then the next paragraph on page 13, sorry, can I go? Is 9, which is about the independence of the Public Procurement Office.
We've covered this. We've covered this, right?
Yeah.
Is there anybody who wants the PPO to be a standalone thing? So for now, it's fine where it is. Thank you. Let's move on.
Okay, then page 14, paragraph 10. Well, it's the issue raised. I think it's related to the question of cost, what it will entail if targets are set, and it's not now contained in prior prescripts, dealing with the costing and not having sight of the regulations, and saying Treasury must commit to funding and so on. I think that the point that which I did mention earlier, is that the draft regulations, according to clause 64, there must be a statement of need and the expected impact. And that will be subject to consultation, and obviously the the cost of instructions and regulations will be relevant consideration during their development. Yeah, I think that's, I'm going to pause there. Thanks, Chair.
Can I just ask a question before we get here? If you turn to page 13, right? Paragraph 9, targets for set-asides. Just look at that. Oh, the following are suggested. That's what we looked at. Okay, I get it. Okay, sorry. Can we continue? Anything else you want to say?
No, not on I think.
Okay, on this one,
10.
any responses from members? Nope. Okay, let's go on. It's emergencies now.
Okay, yes, there's a definition of emergency in clause 1, and then also there's reference made to the provision in the regulations that the power to make regulations, and the concern was that yeah, I don't know, I can't even pronounce some of the words. Sorry. Yeah, I think they're concerned that the regulatory or the emergency procurement will not be adequate. And referring to the China model, and where they actually exclude emergency procurement from all the prescripts. Now, our view is excluding emergency procurement from prescripts will not accord with 217 of the Constitution.
Yeah, and we won't agree with that. I don't think anybody's going to agree with that. Anybody wants to take this? No. Can we move on, please?
Then 12 is the issue of the framework. And the complaint is that we use it frequently in the bill. I think the previous stakeholder made the point that it's mentioned in chapter 4 for the preferential procurement framework, policy. Then it's also used in clause 25, where the minister must set the framework for the procurement institution. Now, our view, well, I think we did allude to this earlier. This is required by 2173 that there must be a framework. And then in 25.1, it's for then when the minister determines a framework for the procurement system that the institution must then develop and implement. Yeah, I don't know, that's our response to that issue.
Yeah, I'm for it, but let's hear anything. Nope. Let's go on. Well, people will interrupt. I'm not going to keep asking, colleagues. You just come in when you want. If nobody says anything, we take it they're agreeing. And even if they come back to a previous point, okay, can we move on, please?
Well, the next one is basically, I think, similar to some of the other stakeholders that we should go back and restart.
Yeah. I just said no, N under my notes. Yeah, good. Can we move on?
Okay, then the next stakeholder is willpower. The first issue they raised is in relation to the application of, they're proposing that the entire bill should apply to Parliament and provincial
No, but we've covered this. Can we jump this? We've said no. Yes. We can't do it anyway. That's one of the first things we agreed to the other day, yeah.
Yes. Okay, the next point is on page 16, paragraph 2. Now, the stakeholder raised a concern about the provision that says that the bill will also apply to donor funding, unless there is a provision for exemption in clause 62. And they're worried about that they will lose funding from certain donors if that's the requirement. So our view is that even if you procure with donor funding, it should be subject to the bill, and that the provision for exemption, so it's in clause 62, not 621, of the bill, and also the requirement for regulations on matters that are where funds are received from donors, that would suffice to deal with, and not.
Yeah. I mean, who's going to argue with that? Anybody? No, that's fine. I just put notes here. No. Okay, let's carry on.
The next issue in paragraph 3 commentary goals.
Yeah, we've covered that.
That's dealt with. And then in paragraph 4, it's about the list that deals with designated groups. And concern at 8.3, it's limited to only one. Now, the clause 18.1 provides for one or more bases for pre-qualifications, while 18.3 which refers back to the category where you can subcontract. So it was on purpose done that you can only select one of those, because otherwise it's going to be very complicated to implement if you're able to select more than one. And the concern was raised in relation to using people in a particular geographical area. But in our view, there's sufficient other provision for that in the bill. It's in set-asides, pre-qualification and subcontracting. So there's sufficient provisions for local economic development.
Any issues here?
Yeah,
No?
Chair, I'm not sure that I buy that.
Yeah, okay. Explain.
You know, I have a real problem with the fact that, yeah, so the geographical issue. So if you want to target young black people in Midvaal, you can't do it. You can either say young black people, or you can say black people in Midvaal. You can't say young black people in Midvaal. I don't buy that. I don't see why that can't be done.
MP?
Chair, I'm going to ask Willie if he can assist one of the other colleagues.
Thank you, Chair. I think in clause 23, there is a provision for a geographical area. That's a Chair. When looking at all these issues that we're talking about here, it does make provision for consideration of a geographical area. Thank you, Chair.
No, but I think the point he's making, if I'm correct, Dennis, I don't know, is that there may not be, sadly, sad to say, is that the point you're making? That category of person in the local area. But in the next municipality, there will be somebody who can do the job and who can qualify. Is that what you're saying, Dennis?
No, Chair. Willie's inputs are actually helpful, because I think, you know, clause 25 then brings a conflict in with clause 18, because clause 18 1C V, so Roman V, so Roman 18 1C5 says a small geographical area. Okay. And then 18.3 says the procuring institution may only select one of the preferences identified in paragraph C of subsection 1. Okay. But then 27 says, sorry, where was it? 25 says you can, no, not 25. Sorry, Mr. Matavula, which paragraph did you point out? 23. Yes, 23. Beg your pardon. When procuring, a procuring institution may, in accordance with prescribed conditions, provide for measures to advance the creation of jobs within a particular geographical area. They seem to be in conflict with each other, because if you're saying, or yeah, if you've got paragraph 23, then why do you need paragraph 18 1C5? Because local municipalities have got local economic development targets, so they very often would like to focus on a specific geographical area. Paragraph 23 gives them that ability, but then paragraph 18.3 seems to limit them and say, if you are focusing on a specific geographical area, then you can only use 18C5. You can't say a small enterprise which is owned by black people who are women within that geographical area. 18.3 limits you and actually negates the intention behind 23. I'm not sure if I'm making myself clear. I think I am.
No, you are. But whether you're right, I don't know. I'll have to look at it carefully. Can you respond, MP?
Chair, I think we must just, clause 20 deals with designation of sectors for local production and content, and that will apply across the board. Where there's a designation by the Minister of Trade and Industry, under 23, it will apply regardless of anything else. That's in terms of preference. So I think we should just not mix up maybe 20 and 18. And if it would help, maybe in our explanation of chapter 4 and the proposed amendments on Friday, we can more specifically deal with Mr. Ryder's issue.
Okay. Can we park that off, right? Let's park this off because it's the only issue we're parking off for no decision making at this stage. Thanks for that, Dennis. Even if we find that what you're saying is not accurate, it's very helpful. Thank you. So Esther, just note this, please, man. And MP, you're going to note it, obviously. You're going to deal with this tomorrow afternoon with your new document, right?
Yes, Chair.
Okay, let's call it ND for short. Your document, right? Let's go on. Dennis, you want to say anything before we move on? Are we parking this now?
No, let's park. Give me time.
It'll also give me time to read tonight. Okay, good. Let's move on, please.
That was paragraph 4. Then paragraph 5 at the bottom of page 16. Now the stakeholder recommends regarding premiums that we a framework be set for parameters in the bill, which may include minimum maximum determinations. And then they again request the regulations be made available alongside the bill. I don't think maybe we don't directly respond to the issue of setting a framework for premiums in the bill, but in our view that would be dealt with through the regulations, which will follow a process as explained before, of consultation and then also submission to Parliament.
All right. Anyone wants to respond? No.
Yeah, I've thought quite carefully on this point. And when you start working with premiums and you start saying that a premium, and you start quantifying what kind of premium is allowable, that becomes your new base level. So, if you're saying that, we'll allow a deviation of 20% from a certain thing, a certain amount, then that becomes your new bottom threshold. Everyone aims for that and takes gouges as much as they can. So I understand the thought process behind the input or the proposal. But I think that the lived experience is such that actually quantifying that becomes counterproductive, and it ends up increasing your procurement costs. So, if there's a better, deeper model proposed by the stakeholder, that could probably be considered, or possibly could be considered. But just as a broad statement, I think that we would all struggle to find something that is really workable. And again, to legislate that would be to invite abuse.
No, I agree. Do you want to reply, Treasury, to what Dennis has said?
No, sorry. We would like to copy his response into our response. Thank you.
Copy some of your salary across into my account.
Yeah. No, it's funny you said that because I was going to say the same thing. Dennis is very clear, and maybe even clearer than you guys are. Why don't you? Yeah, I was going to say the same thing. All right, let's move on. Thanks, Dennis.
The next, I think it was the issue about, because there was an error in 18.1b that referred to 18.3 instead of 17.3.
Yeah,
so it's a correction.
Let's move on. Yeah, let's go on.
Okay, and then in paragraph 7 is a stakeholder's issue about defining the concepts of types of procurement methods, requirements and procedures, category of procurement. Our point was that, well, these terms on their own would have their ordinary dictionary meanings, and there's no need to define them.
Yeah. Can we move on, please? I don't think anybody.
So we're not really.
So let's move on. Thank you.
Paragraph 8. I think it's similar to what we dealt with before, raising the same concern about procedural matters, which we already proposed to be removed. Then paragraph 9, that's about creating the single platform. That's the ICT system, and raising that there will be financial costs to implement it, and that also say there may be costs for provinces. I think we responded, and you indicated the report will also reflect on the cost implications.
Yeah, let's
but
move
again,
on.
Then clause 10 is about the concern that, well, there's many matters to be prescribed and they don't have sight of these as it is now. But again, we say there will be a process for, to
Consult and all
follow
that.
it.
Yeah, but you know what I did like, colleagues, and in a different context, maybe MP should do this, right? Where we feel uneasy about the level of prescription, it's never been done before. But I like this proposal that was mentioned earlier, that why don't you give a copy of the regulations to Parliament, right? Side by side with the bill. So the MPs and the civil society can see what you mean to do. But of course, the minister can always change those regulations, right? A year later. So it doesn't mean that because we get it with the bill, therefore, it convinces us it's right to provide for regulations. But I like that. But I'm not going to do anything about it. Anyway, I'm gone in another few weeks. But anyway, something you guys, well, in the plural sense, was meaning non-binary sense, it's something that maybe we can put pressure on the executive over the next few years to actually do. But anyway, the key regulations. Anyway, let's move on. Excuse me.
The next one is, I think that's the issue. It's paragraph 11 about asset management, which we will agree with the stakeholder that should be removed from, which we indicated earlier. Then 12, contract management, a similar suggestion is made, but we argue that it should be in the list, or we retained in the list which we indicated earlier, but we do indicate that proposal we made that it will be the institution to decide where that would be done, contract management. It doesn't have to be in a supply chain unit. So that's
comments on that, colleagues? No? Right, let's move on.
The next one is about the tribunal panels, which I think an earlier proposal we made when we responded in the comment matrix is that we will provide in the rules for the presence for in provinces, but we do propose that maybe it's better to specifically deal with it in clause 47 that deals with panels, that the panels must function in provinces as well.
Yeah, clause 47 is fine. Let's move on, unless somebody's got an issue. No, right. Paragraph 14, I think, now.
I think it's similar to the other stakeholder about worries about losing grant funding if there's during the standstill process and so on. But we do think the exemptions from donor funding or possible exemptions that would assist, and then also that the regulations on donor funding will assist with that. And I think some of the proposals made in terms of at the end of that proposal about that sorry, I just want to read again, like corrective access rather than preventative, to simply just pay damages to the aggrieved bidder. In our view, that I think from an accounting auditing perspective, it would be fruitless and wasteful.
That's how I see it. Anybody got an issue? No. Can we move on to Samad?
Okay, Samad.
I think you go a bit slower here, right? Because there are things that they say that, I mean, they're dealing with the health sector, and that's too sensitive. I must say I couldn't quite understand why they were saying certain things here, colleagues, because I thought you replied, but they still persist. So here's an example of where we have to write to them and find out. But I'm not sure at this stage. Maybe you'll clarify today. Can you go a bit slower on this one, please?
I think the first issue they raise is that they're concerned that we will have a one-size-fits-all for procurement system which includes medical devices, which what I point out is very unique. I think our main response is that we do acknowledge, I think from the very beginning, that you'll need different regulations for different categories of procurement. And even in this area, maybe different category procurement institutions like for health departments or maybe specifically for the NHI when it comes in effect. So that I think it's a very short response, but I do think it deals with the issue they raise.
Yeah, but can I ask a question, right? In my notes, it says, so why are they unhappy? Why can't they see it or accept what you say? Why would they persist on this? When your answer is straightforward and simple for what I can see. What is it that they see that we can't see? Why are they straightforward? What's the problem? So this might be a question, or maybe I should just phone them and give you the answer. I know, we have to have it in writing. So what's the problem here? I don't follow. Why? Get my drift, Willie?
No, thank you, Sha. I think your guess is as good as ours. Because I mean, the point that you're making, that this thing is quite straight. We're talking about differentiation. To say the regulations will address different types.
There's no one size fits all at all here, from what I can see. It's so straight, so obvious. Okay, let's just note this. Maybe we should write them a question and tell them we're not sure why they won't accept what's here. Okay.
Jay, before we move on.
Yeah.
So, I mean, I understand what they're getting at and so on, I think, but also not to the extent that their concerns haven't been addressed. Can I just ask Treasury, though, in terms of a bid committee process, is there anything preventing or is there anything encouraging a bid committee to receive technical inputs as part of their process from some sort of an advisor? And I mean, so the issue is this: a bid committee for a small municipality will not have a broad, not necessarily have a broad understanding of many different technical aspects of the departments that they are servicing. I mean, you would have one bid committee servicing an entire municipality, I'm guessing. So you're not going to have people on there that understand the implications of a technical specification and may not be able to evaluate it properly. And I mean, this doesn't only relate to small municipalities. It might relate to all sorts of some of our bigger departments. So one only has to look at Transnet procuring trains and then finding out that the trains are 3 inches too high or whatever, or that the wheelbase is the incorrect width, etc. You know, things that we've genuinely experienced before. Is there anything preventing a bid committee from calling for expert opinion or for a kind of an end user department from proposing an opportunity to get a technical specialist to present to a bid committee, and then at the same time, maybe even taking it a step further, getting a bidder to ask for technical evaluation, I guess, of their bid by maybe independent source or by someone within the department, the end user department.
Yeah, but I think that's covered, isn't it? The thing about you can bring in experts, doesn't that cover it? The first part of his question, or the first question.
Chair.
Yeah.
Can I add?
Yeah, of course.
Yeah, I think Honorable Ryder is right. In the normal circumstances, we have consultants, we have quantity surveyors, we have all these professionals who are supposed to have done their work and seen that this train or what we have, this train will not fit. But somewhere between the lines, somebody missed it or somebody just decided
At
to
what
do it.
cost,
without-
Dikeledi? At what cost? Millions.
Yes. So sorry, I'm sorry about that. I withdraw before I'm being challenged. And that's the word that I said, not what the word I'm raising. So I'm saying it is there. So the issue is the willingness and also the oversight that needs to be done.
Yeah, that's very good, Dikeledi. Right. Respond, please.
Chair, to answer to the question directly, no, nothing prohibits the procuring institution from using experts, and then even to put them as part of the bid committees to advise and so on. But not necessarily the bidder, but at least experts, Chair. So they do in fact get experts to come in and sit and advise and so on. That's allowable, even in terms of the current regulatory framework. Thank you, Chair.
Yeah, can I also say, I like what Dennis said. You know, the cost can be borne by the bidder, except that, you know, they're likely to choose a so-called independent technical advisor that will lean towards their bid, you know. But I like that idea. Why shouldn't they pay rather than the state? If they really have a good case, well, they'll pay, and then they'll get the profits from the bid if they're successful. But anyway, I get it. We're not going to do that sort of thing. But for the rest, you've answered it. You want to respond specifically to Dikeledi?
Yeah, look, Chair, I think the issues around the cracks that may, ensue as a result of procuring institutions not doing that quite correctly is costly. It comes at a cost, but I think it's an issue of education of procuring institutions to make sure that where they don't necessarily have internal capacity in terms of expertise, they are allowed to get that expertise from somewhere to help. Thank you, Chair.
All right. Is there anyone else to follow up? No. Okay. Then the next one, please.
The next one deals with clause 19 of the bill that provides for subcontracting. And the concern is that in the medical device sector, it's quite limited, and I explain the process. And I think that if you look at clause 19, we specifically say where feasible, because we know in many sectors it may not be possible to subcontract because of this very reason. So we think that addressed the concern.
Any comment there? See, there too, I couldn't understand why they're raising it, because it says where feasible. It qualifies it. Why would they still raise it? Look, this is another question, Esther, we need to ask them. What is the issue here? Okay, the third, paragraph 3.
I think it's similar to the first question, is that how would specific medical device procurement nuances be addressed sufficiently? And again, we say there's variation or differentiation, as Mr. Matabuda put it, allowed or provided for in the regulation making power in clause 64.
Yeah, but they say that the concepts of value-based procurement and bid specification committees, they were in the previous version of the bill, and you removed it. Is that correct? And why would you have removed it?
Yeah, I'm not sure about the value-based procurement. That was in clause 2 under the objects. There was the issue of value for money, which we now is replaced by a reference to section 195 of the Constitution about effective use of public resources. As to bid specification committees, I don't know which version they refer to, because the bill that was tabled provide for a bid committee system and in clause 29, but we don't specify what committee should be in the bill. it doesn't provide for it, because there's for certain kinds of procurement there will be, for instance, not a specification committee, and some there would be. So that will be dealt with in the regulations.
Yeah. If I may also just add, Chair, to what Advocate is saying. Look, what they're talking about, the 2020 bill, which was, consulted before the bill that went to NETLAC, to say in that bill, there were issues like strategic sourcing, of course, which tracks the value of what you consider when you're doing procurement, in this case of medical technology, where they're talking X-ray machines and so on. Now they're saying in this bill, we should bring that back. Yeah, but what we're saying, if you look at clause 25(1)(a), we do talk about the strategic approach to procurement. Okay. So that's one thing that we're talking about. And we're also talking about, because strategic sourcing is just one of the methods to procure. And then we also, in that very tone, Chair, in clause 64(7), we do make mention of the fact that there would be different regulations for different, categories of procurement. That's basically what we say, and that's the whole issue here. So, and this is what we're trying to say. It's not completely correct that it has been taken out. Thank you, Chair.
Okay, I'm fine with what you're saying. The only thing is, in the bill itself, we can deal with it later, but while we're at it, maybe now. You see, you talk about 25(1) there that's got strategic approach. Now, if you read the word strategic approach, it's not defined anywhere, right? But do you think it's clear enough, MP, as the drafter, what a strategic approach means? You read the sentence, right? I know what you're trying to say, and you give a very good context for that term now, Willie. But I hope that term, strategic approach, is meaningful in some way to an average person who has to read this thing and be part of the structures that are dealing with this bill. I've not seen this term before in any bill.
Yeah.
That I know.
No, what it simply means, Chair, you take the total cost of ownership. So in other words, if you were to procure, you must take all the costs involved into consideration before you arrive at a decision. That's basically what it is.
Can I ask you a question then? Do you think it's not necessary to have just what you just said as a definition? Or is it self-explanatory? I don't know. In the beginning, when you're defining terms.
It can be done, Chair, because I'm sure maybe we're biased because we're practitioners. So maybe it's for us practitioners who understand it, but other person may not understand.
Yeah, and even somebody who's going to be part of implementing this bill in a bid committee or wherever. So, okay. I think we should say to the colleagues that we want a definition unless they come to us and say, like sometimes it is impossible to have a definition, or it's unnecessary, or it will, undermine some constitutional words that could be interpreted in 5 different ways. Okay, so I think for now, do a definition. If you feel you can't do it, we won't kill you for it. We'll let it go. Because I think, it's clear maybe by looking at the bill as a whole. Dennis, I think, has got something. Clear definitions make for better. Yeah, we all agree with that. Very profound, Dennis. Very profound. Okay, can we go on, please?
Chair, the next one is, so to make sure that it's paragraph 4 on page 20.
Yeah.
In terms of how subcontracting will work, and how we ensure that the subcontractor basically complies with all the requirements of SAPRA and their context. And again, we're just saying that it would only be feasible. And in the case if the subcontracting will be bound by the specifications as per the bid, and it will be an agreement between the the successful bidder and the subcontractor. So,
and the next one's also clear, right? If it's not feasible, it's not feasible. Yeah. Okay,
yeah.
can we go on? There's no suitably qualified person. Okay,
Yeah.
paragraph 6.
6, yeah, I think the concern I raise is that, how do we prevent fly-by-night, unqualified or unsuitably companies from setting up subcontracting? And then I refer to what happened during the COVID period. Now, her first point is this is not the role of this bill in our view that should regulate the establishment of new enterprises. And then again, the main contractor must ensure that the subcontractor is suitably qualified to perform the work.
Okay, on this one, colleagues.
Yeah, Chair, I'm sorry. So this opens up quite a big discussion in my view, Chair, and it talks to this issue, and it's not necessarily aimed focused at the health industry and at SARMED's inputs only, because I actually had a note to raise it when we're discussing COSATU's submissions. But the issue around construction mafia and the business forums, etc., that have been set up and effectively have stymied many government projects, government-led projects, because of a throwaway comment by an ex-president that related to 30% local subcontracting, and it's become a problem that has now impacted every single government department. Perhaps this is a very broad question, but what does the current legislation do to try and ensure that these unqualified, basically groups of henchmen and thugs coming on site and demanding 30% of the contract value? What does the current legislation do to prevent that or to formalize the subcontracting? Because essentially what's happened to date is that our contractors are left to deal with the thugs and the henchmen. So government kind of does the procurement and then stands back. And it's very often the contractor that gets the threats, gets their equipment damaged, gets their staff harassed, and so on, and often assaulted. Is there anything in this legislation that tries to formalize that process?
Anybody else want to say anything? Look, I must say, I independently said here in my response, can't you do more? You're leaving it to the main contractor. So much of skullduggery is taking place, even with COVID, right? I know what you're going to say. It belongs to other departments, maybe DTI and registering companies and in the Hawks and police and so on. But I just felt that something more needs to be done. I don't know if we can go into this bill, but certainly, Esther, this is something we need to say in the report about the need for policy and action in this regard. I don't know how we word it, Esther. I'm being very loose and vacuous in general, but maybe by the time we get to write the report, some of us could be clearer. So, in short, can't you do more in this bill? Why not, if not? Over to your team, Willie.
Yeah, thanks. I think it's something that we've never applied ourselves on, but I mean, we're taking a point that maybe those unscrupulous subcontractors and so on. But of course, we just need to look at how do we deal with this so that you also don't exonerate the main contractor completely from its contractual responsibility.
Yes.
Yeah.
That's a nice. Yeah. That's what I think I'm saying. I didn't realize what I was saying until you said it. The main
Yeah.
contractor can't get away. But on the other hand, Janice is right to say, we know about it here in eThekwini and about a half a kilometer from my home, about what happens to the construction mafia. Right? And those were or are targeted for MK people, right? Military veterans, not MK, just military veterans generally from the non-statutory. Of course, I was being facetious and teasing, but when one of them raised it with me, I said, how? Where's your AK-47, right? I didn't mean he must literally go and mow them down. I said, can't you let them know that this is an MK area? But now it's getting very confusing with MKP, right? There was no MKP there. So now people will think it's MKP. But it was raised with me by two people in a meeting situation of the ANC. And this is what is happening and nobody's coming. Exactly what Dennis says. I said, do they know it's an MK project? And they weren't amused, actually, I must say. They knew I was joking, but they weren't amused. They were angry that we're doing nothing. But anyway, I think we're moving forward here and we're asking you, but if you can't do it, you can't do it. But you give us reasons why. Okay, paragraph 7 then, at the bottom of page 20.
Yeah, I think the concern from the summit is that subcontractors will add to the price or make a markup on the price. And how we deal with that now, unless we don't understand it, because obviously the price will be as per the tender awarded. And it's between the main contract and the subcontractor, what the subcontractor is paid. So that's our response.
Anybody wants to come in here? MP, can I suggest something? Maybe it's unfair, right? Can you, not now, but by Monday, give us a direct pithy reply to each of these things that you've said, beyond what you've said, just pithy, precise. And I'll use that as a text to write to them. But questions from our side as Parliament, what's the problem? And if need be, because it might be faster to do it, talk over the phone and then tell the person, okay, this is what you might want to write, half a page to us to tell us why. So it might help. Can you do that?
Yes, Chair.
I'll say this is what Treasury says, and we agree with Treasury. Unless you can show us something, we don't understand why you're raising some of these things because they seem to us to be straightforward, right? So like this one as well, I thought they had some substance to what they were saying, but now you're saying, but it won't change the price because it's really between the contractor and the subcontractor. But I also know what they say. All right, you know what? You do that. I will write to them with cooperation of Esther. Okay, next thing.
The next thing, I think it's the same response that we provided to the previous question about ensuring economies of scale.
Fine. Okay. 9.
Then clause 9, I'm going to try to explain it. Their concern is about procurement under the NHI bill once it come into effect. Now, the NHI bill in clause 38 specifically provides that procurement, and that will be procurement by the NHI fund, are subject to public procurement laws and policies of South Africa that give effect to 217 of the Constitution, including the Triple PFA, which was applicable, well, still applicable, and the Triple BE Act. And then also the further point is in terms of the NSI bill, the fund will become a 3A public entity, and according to our application clause or the application in the bill, it would apply, the procurement bill will apply to the fund. The NHI bill has a conflict, call it a override clause, which says there's conflict between it and other provisions of another act in the NHI bill will prevail. Now, in our view, we don't think there's going to be any conflict because of what I explained earlier. And in any event, there is a statutory interpretation rule that a later act trumps an earlier act. But the mere fact that they act say it's subject to public procurement laws, I think suffices. And then also we have a trumping clause in 3.4 about when it deals with procurement matters. So we don't think there's a problem between the NHI bill and the procurement bill.
Anyone else come in here? I also can't see it, but I don't know. I can't see it. Okay, BBC 2.7, page 21, bottom.
Yeah, the BBC, they are proposing that in clause 17 set asides 18 pre-qualification and 19.1 subcontracting, that categories that are not black people or owned by black people, so and then it should be clause 18. Well, that those be removed, all those categories, and then but they do retain small enterprises within a geographical area in 18, well, not 8.1. Chair, I feel like maybe it's like this recent court case. Maybe a white person shouldn't speak about this.
No, that's irrelevant. Jeremy Cronin is a white person. Derek Hanekom is a white person. No, you give the view of Treasury, not your personal view. Got nothing to do with your skin color. You're giving us a reply from Treasury.
Okay, just on a lighter note. Now, our view is that the removal of women, people with disabilities, youth and small enterprises and cooperatives who are not limited to black people and black owned, it's not supported. In our view, the categories selected in these sections accords with 2172 A and B. Firstly, it deals with people that's previously disadvantaged by unfair discrimination, which includes, in our view, women, not just black women. And then 2172A is an open category which allows for categories of preference in the allocation of contract. And in our view, like the categories for people with disabilities, youth and small enterprises and cooperatives which are not linked to any color, it's also vulnerable categories of persons that should be assisted through preferential procurement.
Okay, anyone wants to say anything in regard to this? No. So I think basically, can I use this?
I think I'm comfortable.
Good. Okay, Dikeledi. Fine. Thanks for that. That helps because it helps the chair to steer the meeting towards position on this. Yeah.
I wanted to speak on what Imp is talking.
Yeah.
Say, I don't see anything wrong in specifying the preferred preferential candidate, and once we do that, we are dealing with this legislation. It's something that should not go or be implemented far from the policies of the government of the day, that black people or previously disadvantaged, let me say, young people, people with disabilities, women, are prioritized. Hence, we even have specific departments in the presidency that are dealing with that and emphasizing issues related to people with disability and women and young people to be part of the budgets. When departments are dealing with budgets, we have committees that are specifically focusing on that. So I think this is going to help us. I'm just emphasizing here to say, why am I agreeing with that, to have that?
Okay, so if I understand you correctly, what you're basically saying, look, let me take an example, right? So they don't want us to refer to a generic term, must all be black, right? So if that's the case, in the first instance, I think what Dikeledi is saying is that until now, that's not been the policy of the government or the ANC. So for example, you can't say, for example, you can't say you can only benefit black people with disabilities, right? I mean, a white person who's stuck in a wheelchair is also a human being. They may vote for the AWB or whatever. We can't exclude them, right? You have youth white youth who have finished university as well. And we can't say you don't matter because you've got this degree and all that. You see, it just, I mean, I agree with you, Dikeledi, if what I think you're saying. You see, the ANC has had this before. There's another issue that arises, which is why are we using the collective term black? Because see, if you take KZN into account, right, it's a fact that, well, unless somebody can prove otherwise, some contest this, that Indians are disproportionately benefiting from BE. Now, this discussions have occurred every now and then, and the ANC keeps coming back to this, as does the Premier and the MECs, that, yes, we acknowledge there are difficulties, but that's a practical issue that we have to apply. We can't change the policy because it means changing a whole lot of legislation. The ANC must change its meaning of the term black and the term used in all the legislation from 1994. There are other ways of dealing with it. Similarly,
and the Constitution.
Yeah, similarly, I understand what people are saying, that why are white women there instead of just black women? And I understand why they're saying it, but you see, you have to be fair. I mean, women, even white women, right, under men, subordinated by men, right? Even though they were beneficiaries overall, they were subordinate to men, and they have things in common. They may not all recognize it with African women and women of color generally, and so on. So I agree with you, Dikeledi. This is the ANC policy. This is the way in all the provision, and somebody's going to go to court and challenge us because we are opposed to gender discrimination. Am I not a woman? No, my name happens to be Mrs. Fantonda. So I agree with you. I'm glad you're saying it because I feel that it's giving us direction, and anybody else who says otherwise, I think we agree with you, Treasury. In any case, you hidebound to respond like that because that's the government response. But we must also empathize with people who have that view because we have failed. All of us are saying it. Even the leadership of the ANC says it, right? With triple BEE, to ensure that the distribution of resources are fair across all and reasonably representative of our population, but even within population groups, like we keep saying. And tomorrow we'll discuss it. What percentage of those who are beneficiaries are actually from small businesses and lower income classes and unemployed people and so on, where they can have small projects to get going by our affirmative action policies. So those things will come to tomorrow. So I think we agree with you. Can we move on? Unless somebody else will say anything else. Nope.
Chair, can I just add one thing? Which is now not in our response. I think an important provision in clause 17 when we deal with set-asides, which was a provision that was that came through obviously the NA, is that the minister is required to set targets after consulting with the relevant ministers. So for instance, this thing about setting targets for women as a group or as for black women or for black people, that is provided for. But he doesn't have to set targets for all groups in 17.3. So he can or she set targets for instance, just for black people in general. And then those targets would apply over and above the other requirements, which I think then in a way elevates groups that has suffered more, if I can put it like that. Which is, it's in 17.
Yeah, I think you're over-explaining, but okay, fine. Yeah, we get it. But you see, there's another thing. In practice, what will happen is it will primarily Black and African and so-called colored, I would imagine, that benefit, right? Because that is the way things are in the economy and society we live in. So, yeah, I think we understand why people are raising it, but we beg to disagree. We agree to disagree, right? Can we move on?
Okay, the next, it's on page 22 at the top, where they say in order to promote innovation, we should provide for single source procurement. Now, I think our response is that single source procurement or sole source procurement would be one of the procurement methods. And we did acknowledge that the definition of bid should be amended so that it allows for.
Yeah, fine. Okay.
Yeah.
Okay. Can we move on?
Then the next one is the requirement to for the minister to consult on the regulations. Now, I think they were referring to a provision that was in the, it was either prior to tabling or the tabling, I can't recall now. But we moved that requirement to clause 64, where the minister must consult all relevant ministers.
Okay, fine. Let's
And
move on.
4 is a provision that says the minister,
Of
any
course,
minister
that's
may
straightforward.
request,
Yeah.
and we say, well, we don't have to have
Yeah,
that.
yeah, that's right. It's understandable they raise it, but we know this is the way things have
Mm.
always functioned, right?
Yes.
Okay, in practice, business unity.
Business unity, what there's a long input with several matters that I raise, and then there's specific issues. There's a response on the first page, which, well, I think they complain about the way Treasury responded. It's a copy and paste matter, and and so on, and about the constitutionality, and also about, they complain that we don't respond as cordially to them as to COSATU. Now, so Treasury, I think the first point I want to make is that obviously there were some comments. If it was similar, we would copy what we said before to be consistent. And yeah, the bill that was tabled was certified by the state law advisors. And I think on constitutional issues, Advocate Jenkins dealt with that on earlier this week. So we're going to go further. Then on the next issue, well, they're supporting, I think the main issue under paragraph 2 is the issue about value for money. That they raised, and they also raised whistleblowing, and they're concerned about the bill basically deconstructing the BBBE Act and its sector codes.
Yeah, that's a big issue, eh?
Yes.
And it's 12:56 now. That is worrying. It came across later down the road. There's somebody who suggests that this bill trumps the BBBE in ways that actually take us backwards, right? And I really want you to reply to that. But we're at 12:56. So what I want to suggest is we can't finish BUSA. It won't be right. We have to give them the attention. They're quite important. So we're going to end in 3 minutes, right? So which paragraph can you respond to, and we can conclude the matter on? Quickly.
Just on that, the BBBE Act, I think we could respond when we deal with chapter 4 in totality on the BBBE issue as well tomorrow.
Yeah, okay. But now what you
quickly. Can I interject? Yeah, I just think that, for the sake of continuity, maybe we should end 2.5 minutes early. I'm sure in your closing speech you normally take more than 3 minutes anyway, but I think it would do more justice to Bruce's inputs if we handle it.
Okay, fine, we agree. Anybody have a problem with that? No. Okay, thank you all. We'll see you at 2:00 on Friday, and I have no doubt we'll finish this and do the other 2 tasks we have for tomorrow. So thank you all, much appreciated. Thank you, Treasury, and we shall see you tomorrow at 2:00.
Thank you, Chair.